in, and then we will get started.
How you turn this up?
Let me tell you, let's see, I've got Mr. Simpson. I know you're on here. Your guys are in Barron County Detention Center. It'll probably be just a few minutes because they're gonna, they're doing district court first. So we'll have to get you to hang in there. We've also
I think he does have one that's out of custody. That's Stephen Tang.
Yeah, I haven't seen Mr. Tang on here yet. Unless, well, this could be him. It's just said a first name, Stephen. That could be him. The camera's turned off. But he looks like he's conducting some business anyway, Mr. Simpson is. So I'm going to move on to look at the Warren County Detention Center or Warren County Regional Jail over there. They've got 2 people. We probably can get in and out on those real quick, I would think. One of them is Mr. Logan, and one of which is Mr. Spears's case, I think, and he just now got in the waiting room. So let me let him in. And then another one, I think, is Mr. Fleet. And so I'll probably need Josh for both of those anyway. Mr. Spears, can you hear me?
Yes.
Are you ready to go on Mr. Logan in Bowling Green?
Yes, we are, Your Honor.
All right. Mr. Logan, are you with, can you come up to the camera? All right, Mr. Logan, can you hear me?
Sir, I can.
All right, very good. Can you raise your right hand for me? Do you swear or affirm that you will tell me the truth, so help you God?
Yes, sir, I do.
All right, Mr. Logan, I have some paperwork here that indicates that you guys have hammered out your differences and reached an agreement in this case. Is that right?
Yes, sir.
All right. Do you see this motion to enter a guilty plea?
Yes, sir.
That look familiar to you?
Yes, sir. I signed it this morning.
All right. Is this in fact your signature?
Yes, sir, it is.
All right, very good. Did you read over it before you signed it?
I did, sir.
Thank you. Did you have time, if you needed to ask your attorney any questions, did you have time to do that?
I did, sir.
This is the Commonwealth's offer on a plea of guilty. Does that also look familiar to you?
Yes, sir, it does.
All right. And did you sign it as well?
Yes, sir, I did.
All right. Did you get the chance to read over it and talk to your attorney about it also?
I did, sir, this morning.
All right. Are you in fact satisfied that you've had all the time you need to discuss these matters with your attorney and to review this paperwork?
Yes, sir, Judge.
Do you understand what you have signed?
I do.
Mr. Logan, do you understand that you have a right not to incriminate yourself? And if you plead guilty, you waive that right.
Yes, sir, I do.
Do you understand that you have the right to have a jury trial where the Commonwealth bears the burden of proving guilt beyond a reasonable doubt? You would have the right to confront and cross-examine the people that gave evidence against you, and you would have the right to put evidence on in your own defense. You understand those rights?
Yes, sir.
Do you understand that you waive those rights if you plead guilty?
I do.
All right. And finally, do you understand that you have the right to appeal and you waive that right if you plead guilty?
Yes, sir.
All right. Mr. Logan,
Yes, sir.
do you feel like you're under the influence of anything today?
No, sir.
Is your judgment impaired today for any reason?
No, sir.
In this case, the Commonwealth has offered the following: count 1, theft by unlawful taking $500 or more under $10,000. That is a Class D felony. The Commonwealth on a guilty plea would recommend a 3-year sentence. Count 2, criminal mischief in the 2nd degree. That is a Class A misdemeanor. On a plea of guilty, the Commonwealth would recommend a 12-month sentence. And count 3, persistent felony offender in the 1st degree, the Commonwealth agrees to dismiss that charge. The total recommended sentence would be 3 years. The Commonwealth the sentence would run consecutively with your cases in Warren County. And it doesn't explicitly say this, but I think it was implicit and certainly it was explicitly stated during the previous conversations that there is, the Commonwealth is not agreeing to probation. Okay.
Yes, sir. Yes, sir.
All right. And in fact, is that what I just told you? Is that what you thought the agreement was?
Yes, sir.
All right. Mr. Logan, other than the Commonwealth's promises to make those recommendations, has anyone promised you anything to get you to plead guilty?
No, sir.
Nobody has, is it fair to say that nobody has promised you that you will get probation?
Nobody's promised me anything, sir.
All right. Mr. Logan, have you been threatened to try to get you to plead guilty?
No, sir.
All right. Are you pleading guilty voluntarily today?
Yes, sir, I am.
All right. Mr. Logan, are you acknowledging to me that, and by the way, before I get there, I did accidentally leave this part out. Another aspect of the Commonwealth's plea offer is that you have restitution that you'll pay. It's $1,100, right?
Yes, sir.
All right. Are you acknowledging to me that on February 20th, 2020 in Barron County, Kentucky, you committed the offense of theft by unlawful taking when you unlawfully took or exercised control over movable property belonging to another person valued at $500 or more, but valued at less than $10,000 with the intent to deprive the lawful owner thereof?
Yes, sir, I did.
All right. Are you also acknowledging that you committed the offense of criminal mischief in the second degree when having no right or reasonable grounds to believe you had a right to do so, you intentionally or wantonly destroyed or damaged property belonging to another person, causing loss of $500 or more?
Yes, sir.
All right, Mr. Logan, I will accept your plea of guilty today. Now, let's talk about sentencing. Have you discussed with your attorney whether you would like to be sentenced?
I'd like to waive my PSI.
Okay. There doesn't appear to be any objection to that. So, Mr. Logan, that seems fair under the circumstances. I will sentence you to 3 years on count 1, 12 months on count 2 to run concurrently for a total recommended sentence of 3 years consecutive with your Warren County cases that you've got over there. You'll have $1,100 restitution. Pay that at $50 a month, beginning 90 days after your eventual release from custody to give you time to get a job and so forth. Your fines and costs will be waived due to indigency. Okay.
Thank you, Judge.
Do you have any questions?
No, sir.
All right. Then that's all we got.
Thank you. Have a blessed day, Judge.
Thank you. Mr. Fleet,
Yes, sir.
how are you?
Pretty good. How are you?
I'm doing fine. Can you hear me okay?
Yes, I can.
All right. Will you raise your right hand for me? Do you swear or affirm you will tell me the truth, so help you God?
Yes, sir.
All right. Mr. Fleet, give me just a second here to get through all these papers. You've signed a bunch of paperwork, right?
Yes, sir.
All right. Let's start with this one. This is called a motion to enter a guilty plea. Does that look familiar to you?
Yes, it does.
All right. And does it have your signature on it?
Yes, sir.
Okay. You signed apparently a waiver of rights. Does that look familiar?
Yes, sir.
All right. And is that your signature?
Yes, sir, it is.
Thank you. You have also, let's see, the Commonwealth's offer on a plea of guilty.
Yes, sir.
Is that your, whoops, wrong page. Is that your signature?
Yes, sir.
All right. Did you read through each of these documents before you signed them?
Yes, it was read to me.
All right. Do you feel like you had all the time you need to contemplate what they meant and to talk to your attorney about what they meant?
Yes, sir.
All right. So your signature, does your signature on each document indicate that you understand the contents of the document?
Yes, it does.
All right. Mr. Fleet, do you understand that you have a right not to incriminate yourself? And if you plead guilty, you waive that right?
Yes, sir.
You understand that you have the right to a jury trial where the Commonwealth would have to prove guilt beyond a reasonable doubt.
Yes, sir.
You could confront and cross-examine the people that give evidence against you. You have the right to put evidence on in your defense, and you have the right to appeal.
Yes, sir.
All right. You understand that you waive each of those rights if you plead guilty.
Yes, sir.
All right. Mr. Fleet, do you feel like you're under the influence of anything today?
No, sir.
Do you feel like your judgment is impaired for any reason today?
No, sir.
All right. Do you feel like you are being made by me or anyone else to enter this guilty plea?
No, sir.
All right. In your case, there is a single count of possession of a controlled substance, first degree, third or subsequent offense. That is a Class D felony. On a guilty plea, the Commonwealth recommends a 3-year sentence. And the Commonwealth would agree to probate that sentence. Under supervision of probation and parole for a period of 2 years on condition that you comply with the rules of probation and parole, specifically that you get an assessment and that you comply with any recommendations that arise out of that assessment as to treatment. You understand that?
Yes, sir.
Also, upon entry of this plea of guilty, the Commonwealth would agree to dismiss the other pending charges, which are disorderly conduct and public intoxication. Do you understand that?
Yes, sir.
All right. Mr. Fleet, other than what I just talked to you about, has anyone promised anything to you in exchange for a plea of guilty?
No, sir.
Has anyone threatened you to try to get you to plead guilty?
No, sir.
Are you pleading guilty voluntarily?
Yes, sir.
Mr. Fleet, are you acknowledging to me that on July 12th, 2020 in Barron County, you knowingly and unlawfully possessed methamphetamine, having at least 2 prior convictions for possession of a controlled substance?
Yes, sir, I am.
All right. Mr. Fleet, I will accept your plea of guilty today as having been entered freely, knowingly, intelligently, and voluntarily. Couple of questions I need to ask you, if you don't mind. Number one, can you tell us your address?
Right now I'm homeless. I don't have an address. I guess I could give you the jails, 920 Kentucky Street.
Well, no, I know well, let me ask you this. Do you have another, this case right here, they're agreeing to recommend probation. Do you have any other cases like in Warren County that you're still going to be serving on?
Yes, yeah, I'm serving a 3-year sentence at Warren County, but they're supposed to, I was waiting on you to see what you was going to do, and I'm going to rehab, I believe, a long-term treatment.
Oh, okay. Like, are you going to get shock probated to go to rehab or what?
Well, I go to court next month. I haven't talked to my lawyer yet. I'll know more tomorrow, but if they don't just, I think they're going to either give me probation for 3 years or 3 years to serve upon completion of rehab.
Okay. Well, most of the main reason I'm asking these questions is so that my probation officer will know where you're going to be in the immediate future, because they need to track you down, but so you don't think you'll be getting out at least until you go to court next month?
Yeah, I'm not sure. See, I'm going to talk to my lawyer tomorrow. I was told I had 3 years to serve here is what I signed for, but I talked to the person that does the rehab stuff, and she said different. She said that they was going to do the 3 years to serve, 3 years probated upon completion of rehab, but I'm not 100% sure of that.
Okay. Well, I'm not sure either.
That's my goal, is to get out and go to a long-term treatment.
All right. Well, Officer Mann, what questions, if any, do you want to ask him? Or sounds like he's going to end up being in jail at least for the next. It's not like he's going to get out today or tomorrow and be able to come visit you all.
Right.
Mr. Fleet, do you have an active phone number right now?
No, I don't, ma'am.
Okay. Do you have an alternate number where we can get in contact with you if you are released?
Yeah, I can give you
what-
my friend David Groves. His number is 270-537-4652.
Okay. And if you are to be released, I need you to call the probation office in Barron County as soon as you're released, and we will get you going from there. Okay.
Okay. Yes, ma'am.
All right. Thank you.
Thank you.
Sounds like to me, though, that anything you do out of those Warren County cases, you'll be be on probation at
Yes.
the very least, right?
Yes, definitely.
You'll be-
Definitely.
you'll have a
Here
probation
and there.
officer.
Yeah, I'll be on probation here and there. So,
All right. All right, Mr. Fleet. Well, on our end, we're going to do, I'm going to do what you and the Commonwealth agreed to do, which is to grant your request for probation. Okay?
Yes, sir.
All right. So you just need to make sure that when you do ultimately get out, that you get in touch either directly or with your probation, using your probation officer over there, you get in touch with the probation and parole office here so that they don't lose track of you and they at least know where you are. Okay?
Yes, yes, sir. I will do.
All right. Any questions?
No, sir.
All right. Thank you.
Thank you. Have a blessed day.
All right. I believe that's everybody in the Warren County Regional Jail. Thank you. Boy, if we ever have to next time we have to meet with you guys, I hope you put them in that room with that headset. That worked like a dream. All right. Let's see. I got all kind of jails going here. Looks like we've got Powell County Detention Center. I got Montgomery County Jail.
Yes, we're Powell County.
Yeah. I got two or three with you guys over in Powell County. So why don't we just go ahead and see who we can take up? It looks like we've got Michael Carlson, Philip Kirby, and Matthew Stapleton.
Okay, which one do you want first?
Does the Commonwealth have a preference, or Mr. Berry, do you have a preference?
Judge, on Michael Carlson.
Carlson.
Uh-huh. Are you Beth by any chance?
I am Beth.
Oh, okay. All right. We've been calling back and forth. All right. Judge, we've got an agreement on Carlson, and I sent the paperwork down, faxed it down to the jail, and they had gotten it signed and it faxed it back, but just the back pages of it came through. So all I've got is the signature pages without the front pages on them.
Okay.
So it's just a matter of us getting the facts straightened out, and it should, we've got an agreement.
Well, let me ask you this question. Do you have the, do you still have your copy of the front pages where you could maybe fax them or email them over here to us or fax them to us, and I could do a couple other people and then come back to Mr. Carlson and we could get this thing wrapped up today.
I would probably need to go to the office and get it, but there, I believe it's at the office. I could just go over
I
and get
have
it.
a copy of them.
Do you?
Yeah.
Probably show them.
I don't know.
Because for
Mr.
my
Barrett,
purpose, all I really need to know is just what, obviously I know what the motion to enter a guilty plea says and so on. And then the other, the plea paperwork, I just really need to know what it says. And then if, as long as I know it's coming.
we have a copy here.
All right. With you?
Yeah,
I
yeah.
do have a copy.
She's going to get it right now.
All right. Well, I'll tell you what,
Ask her to fax it again.
yeah, if she can get that and send it in a fax machine to me. I don't know what my fax machine is.
They didn't want it by email, they wanted it faxed, so.
I understand.
Is it just 2 pages?
How many pages is it?
What's front and back?
Is it-
One document's front and back, and the other one's, I think, 2 pages.
That one's not the signed copy.
This,
Yeah. Yeah, all right. Mr. Carlson, is there a back page to that? What you just showed us, is there 3 pages, a cover page and then 2?
1, 2,
Yes.
yeah. Yep,
Yeah. Yeah, then I need those 2 pages. I don't need the cover page, but I need, and then the thing that says motion to enter a guilty plea, there should be 2 pages of that. Either the front and back or 2 separate pages, one or the other.
today. Hold on 1 second. I'll sign these ones for you.
All right.
Oh, okay. Well, I was gonna say, I've already got signed back pages.
Sorry.
You got an initial by the X the same time. Maybe that makes me.
She needs the fax number too again, if you have it.
Yeah, I got it. You ready?
Yep,
270-651-7051.
Like Sarah now.
all right, we're gonna fax it right now.
All right. Well, I'll tell you what, while I'm waiting on that, let me talk to whoever else you guys got in there, if you don't care, Mr. Carlson, then we'll come back
One
to
of you
you.
guys.
All right,
Judge, I've got Philip Kirby down there also.
All right.
Are you Kirby?
Uh-huh.
Kirby. Sorry.
Judge, Mr. Kirby and I have talked a couple of times on this, and there's a little more discovery I wanted to try to do on this that we're just wondering if it's out there. If it's not, it won't be. If it is, we'd need to get a copy. But I guess my bottom line is we're not ready to do an agreement of any kind on this yet. We'd ask for another pretrial conference date.
All right, that works. You think like April 19th, would that do it?
That,
About 4 weeks?
yes, that should do it, Judge.
And just to,
About 3 weeks.
Okay.
just to clarify, Mr. Berry's talking about additional discovery. Is he wanting something that he feels we have not provided, or is he using his own investigator to
No,
figure
I'm
out?
just, no, there's just a couple things. I'll talk to you about them.
Okay. Okay.
Also, Mr. Berry, if you don't mind, is there any way that I could get you to send me a copy of my discovery when I was transferred? It got misplaced in the mood by some staff, you know, out of my control. So I need a copy of that discovery sent to me, please.
Yeah, we can do that.
All right, Mr. Kirby, I'm gonna move you over to April 19th and we'll see you then.
Okay, thanks, Judge A. You have a great day.
You too.
That's all I have in Powell County, Judge.
All right, Matthew Stapleton.
What? I did.
April 19th, Philip Kirby, Kirby.
All right, so Mr. Stapleton is on.
2:30 our time.
Thank you.
I'm thinking that this is basically a pretrial conference. I'm thinking that we had never really gotten much beyond the pretrial conference stage.
Your Honor, I think it's the first time we've seen Mr. Stapleton. So
Yeah,
all this.
well,
started-
I know I arraigned him.
Yeah, I'm talking about since COVID hit.
It's my
Yeah.
girls.
Things got a little weird after that, certainly.
This is Zanda's case, Judge.
Okay,
Here, Your Honor.
got you. So, what are we thinking about Mr. Stapleton's deal here?
Your Honor, Mr. Gardner and I have been we've spoke just a little bit about Mr. Stapleton. He is actually in an SAP or a SAP program right now. I believe he's going to be finishing that in June. I was going to request that we set his pretrial conference date over to July. And that way he'll already be finished with the SAP program for one, and hopefully he will be placed wherever he's going to be following that, and I can actually go in and see him and have a confidential communication with him.
All right. So you're thinking July does it matter?
Doesn't matter. Anytime in July should work, Your Honor.
Let's call it, you want to call it the 19th?
I think that's a trial date for me. Hold on. As soon as I said that. Oh, no, I should be fine on July 19th.
Okay. July 19th at 1 o'clock prevailing local time. Okay. All right, Mr. Stapleton, we shall see you then.
All right, thank you.
And Your Honor, that paperwork should have come through. We got a confirmation on it.
Yeah, I believe I got it. If you all can we can do Mr. Carlson, but if y'all can bear with me for just a second, because apparently our jail is wondering why I won't let them in, but there's nobody in my waiting room. All right, Mr. Carlson, are you ready?
Yes, sir.
Can you, Mr. Barry, let me get you back on here, okay?
I'm here, Judge.
Yeah. Got so many people, it's hard to find everybody. All right. Mr. Carlson, raise your right hand, please. Do you swear or affirm that you will tell me the truth, so help you God?
Yes, I do.
So I have now received your papers and I need to talk to you about these, okay? First off, this is the motion to enter a plea of guilty. Does that look familiar?
Yep.
All right. And it's got a signature page. Is this in fact your signature?
Yep, it is.
All right. Thank you.
Mhm.
This is the Commonwealth's offer sheet, right? Does that look
Yep.
familiar?
Yes, it does.
And here is the signature page. Is that your signature?
Yep.
Okay. Did you go over both of these things thoroughly before you signed them?
Mhm.
All right. Did you have the opportunity to consider everything that you needed to consider and to ask your attorney questions and things of that nature before you signed them?
Yes, sir, I did.
All right. Do you feel like you are that you have had all the time you need to think about how you wanted to proceed?
Mhm.
All right, Mr. Carlson, you understand that you have the right not to incriminate yourself, and you waive that right if you plead guilty.
Yes, sir.
You have the right to confront, or I'm sorry, to have a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. You waive that if you plead guilty.
Yep.
You understand that you have the right to confront and cross-examine the people that give evidence against you, as well as the right to put evidence on in your defense, and you waive those rights if you plead guilty.
Yes, I do.
All right. And do you understand that you waive the right to appeal if you plead guilty?
Mhm.
All right. Very good. Mr. Carlson, do you feel like you're under the influence of anything? Is your
No, sir.
judgment impaired for any reason?
Nope.
All right. The Commonwealth is offering or has offered the following. Count one, possession of a handgun by a convicted felon. That is a Class C felony. On a plea of guilty, the Commonwealth would recommend a 5-year sentence. Count two, possession of a controlled substance, first degree, first offense, a Class D felony. On a plea of guilty, the Commonwealth would recommend a 3-year sentence. Count three, drug paraphernalia. That's an A misdemeanor, a 12-month sentence. Count four, operating on a suspended license. That's a B misdemeanor. The Commonwealth recommends a 90-day sentence. Count five, careless driving. Count six, improper signal. Count seven, PFO in the second degree. The Commonwealth agrees to dismiss each of those cases upon your plea of guilt, or charges upon your plea of guilty to counts 1 through 4. The total recommended sentence would be a 5-year sentence. There would be forfeiture of the items that were seized at the time of the arrest, and the Commonwealth is opposing probation. Is this what you believe the agreement to be?
Yep.
All right. Other than what I just told you, has anyone made any promises to try to get you to plead guilty?
Nope.
Has anyone threatened you to try to make you plead guilty against your will?
Nope.
Are you in fact pleading guilty voluntarily and of your own free will?
Yes, I am.
All right. Mr. Carlson, are you telling me that you acknowledge on August 6th, 2020 in Barron County, Kentucky, you possessed or transported a handgun having previously been convicted of a felony and not having been the beneficiary of a full pardon.
Yep.
Are you also acknowledging that at that same time and place, you possessed knowingly and unlawfully methamphetamine?
Yep.
All right. Are you acknowledging that you possessed drug paraphernalia?
Mhm.
All right. And finally, are you acknowledging that you were operating a motor vehicle knowing that your license had been suspended, canceled, or revoked, or
Yep.
that your privilege to operate a motor vehicle had some other way been withdrawn?
Yep.
All right, Mr. Carlson, then I'm going to accept your plea of guilty today as having been made freely, knowingly, intelligently, voluntarily, with the advice of competent counsel. Do you know how you want to approach your sentencing? Do you want to do a PSI, or do you want to go ahead and waive that and get sentenced today?
What's PSI?
A pre-sentence investigation?
Oh, no, I just want to go ahead and get it on the roll and get it done with.
Okay. That's, I don't think anybody's going to object to that. That seems.
No, I'm in a SAT program right now, so.
Yeah, super. Okay, good deal. All right. So, Mr. Carlson, I will accept your waiver of a pre-sentence investigation. We'll go ahead and sentence you today based upon your plea of guilty to counts 1, 2, 3, and 4, which I hereby accept. You are going to be sentenced to 5 years on count 1, 3 years on count 2 to run concurrently for a total of 5. 12 months and 90 days also will run concurrently. Forfeiture of the items seized, fines and costs will be waived. Okay?
Okay.
Do you have any questions?
Nope.
Mr. Carlson, that's all I got. Good luck to you.
All right, thank you.
All right,
Thank you, Greg.
Okay, see you, Mike.
I believe.
Your Honor,
that-
that's all I have.
Thank you very much for your
Thank you.
patience. All right, bye-bye.
Bye-bye.
Mr. Richardson, are you on here? You are, aren't you?
Right here, Judge.
Were you on Mr. Carlson's?
I was. I saw everything, Judge. That's what the agreement we came out to.
Yeah, the paper that I have just doesn't have your name on it. Can I sign by me?
That's fine, Judge.
I just didn't want to do it without asking.
Yes, sir.
All right, people. Yeah, up in the Montgomery County Jail, I've got Mr. Both.
All righty, here you go, Judge.
How are you?
How's it going, Mr. Alexander?
Well, it's going all right.
Your Honor, this case was just recently sent to Lee Davis on conflict, and he is actually covering, oh, here he is, never mind.
I saw Mr. Davis. He jumped on here. Yeah, he jumped on here a minute ago.
Yes, Your Honor, I'd like to, I haven't gotten any discovery. I haven't had a chance to talk to Mr. Booth. If we could just set this for 4/19 at 10 a.m. to give me a chance to go through everything, maybe we can resolve this on the 19th. If not, we'll go from there.
I do not have a problem with that. Is it, let's see, is this Mr. Gardner? Are you doing this one?
It's my case, Your Honor. Yeah, I mean, this, the only thing is, this is a 19 case, so it has been pending for a while. Mr. Booth is in state custody at this point. So, you know, I understand Mr. Davis getting into it now, and he's got to get himself up to speed, but I would like to try to move it along as quickly as possible.
Yeah.
Well, Your Honor, it's set for a jury trial in the 2nd, 3rd, and 4th. If I get all the discovery in time, my calendar's free on that date. I'm perfectly willing to go to trial and on June 2nd if we have to.
Yeah, I was going to say we got a trial date that's about 2 months away and a little change. So, I mean, we'll ought to be able to move in one direction or another pretty quick.
And Your Honor, I haven't had a trial in a while. I'm kind of anxious for one, to tell you the truth. So,
Well, I don't think any of us have, I think Miss Myers is the only one that's tried anything in the last year, probably. So everybody's got to get out there and knock the rust off. Okay?
So, Your Honor, could we set it then for 4/19, 10
Yes.
a.m., please?
Yes. Oh, you want to do 10 o'clock?
Please, Your Honor, if I could.
Yeah, that's fine.
Thank you, Your Honor. Your Honor, I think that concludes my business. May I be excused? And Mr. Booth, I'll call you soon And if you have any issues, we'll talk on it. And okay.
All right, did you get all my papers from Mr. Berry?
No, I haven't gotten anything yet. So
That was just put in the mail last Friday. He should receive it soon.
thank you, Your Honor.
Yeah, that's what we're talking about, Mr. Yeah, that's what we're talking about. That's why he's asking me to move this, because that stuff is in transit, and then when he gets it, he'll be raring to go. Okay?
All right, thank you.
All right, you
Thank
bet.
you.
See you. I think that I just had the one person in Mount Sterling, so we can let them go.
Your Honor, I see Mr. Daniels. And he's in a treatment center. Miss Myers is going to be representing him. I don't know that she's spoken with him, but it's something that since he's in treatment, I would prefer to put off to see if he's completed or when he completes it.
Ms. Myers, what do you think?
Had a chance to send him his offer and discovery, but obviously I've not had a chance to have a confidential talk with him because he's in treatment. So I would like to put it off to give me a chance to actually be able to sit down with him and talk to him confidentially. I was trying to see, it looks like it says he's currently in phase 2 and he has to complete phase 3 as well. So phase 3 will be another 60 days. I don't know if that means we can put it out to July and he should be finished with phase 3. I hate to put it out that far, but at the same time, I want to be able to talk to him one-on-one without having a counselor in the room.
Hey, ma'am,
Yeah, I understand.
can you hear me?
We can hear you
Yes.
now.
Okay. I was told by Barron and Warren County to do treatment, and I was on probation, and they would take care of this at a later date. Now they're showing something about no probation, something to do with 10 years. I don't understand that. Why am I doing treatment if they're going to just turn around and throw me out to the wolves or lock me back up when I'm doing what I'm supposed to?
Hey,
Your
Mr.
Honor.
Daniels, we'll talk about that further. You focus on your treatment right now. What I sent you was a previous plea offer, but I'll have an opportunity to talk with the prosecutor about that plea and stuff as we go along. Okay.
I never had a preliminary.
Wait.
Okay. I
Give
never
me a
had-
chance to
Okay.
talk to you. Give me a chance to talk to you one-on-one confidentially so we can go through everything.
And
you
Ms.
find
Myers, hold on, Mr.
Okay.
Daniels. Ms. Myers, just to be clear, because I don't think you were representing him when we had his previous hearing, but there was a revocation hearing. And I don't think there was any kind of agreement about him going to treatment. I think that at the conclusion of that hearing, in lieu of revoking his probation, I sent him back to treatment. So I don't think anybody from the Commonwealth made any promises. I think they were seeking to revoke him.
We were.
So, that's the lay of the land, okay?
Understood. Thank you, Your Honor.
All right, Mr. Daniels, hang in there. Keep doing what you're doing, all right? You need to get better, all right?
Judge,
Yes,
yeah, I'm really doing better, and I told you I wouldn't let you down, but
I appreciate that, all right?
but I don't.
Get up.
My caseworker's right here, and she sent them email. Do you know the length of time that I'm supposed to finish it, or what the phase is, or how long y'all wanted me in treatment?
I do not know. I mean, I just asked your probation folks to get you into treatment, and they did. And then, I usually leave that up to them to, the nuts and bolts, okay?
Okay, I'm doing really good.
Good.
I'm finally, getting something out of it and living a new life. And it's just,
Did we come up with a day of when we were moving this to? Did we say?
That's what I was going to ask you, Judge. I don't have an objection to going to the beginning of July.
Okay, you want to do let's see, maybe the 12th, the 5th will be a holiday. So
Right.
Probably we'll do the 12th or the 19th. I don't care which one.
Either of those. I prefer maybe the 12th if that's closer.
All right.
to when
That's
he's
fine.
finished.
I have a trial beginning in Hart County on the 12th. So can we go to the 19th?
Yeah, we can. I just set that other case for you on the 19th.
I
It
appreciate
is
it.
possible that I'll be gone on the 19th. But we can communicate before then, and if we have an agreement, we can
Sure.
get out.
Yeah, that's, a good 3 months out or something, 4 months out. All right, Mr. Daniels, keep on keeping on, okay?
Yes, sir, Your Honor,
All right.
I will. And thank
We'll
you
talk-
for.
we'll talk to you in July.
Okay,
Mr. Daniels, make sure you contact me the minute you finish rehab, okay?
I plan on staying longer. I want to intern and become staff. I mean, this is something that I want to do for the rest of my life.
Okay.
Well, when you get to
a
where you
chance,
can call your
contact me.
attorney, call her and get in with her and talk to her, okay?
I got a case manager right here and I can use the phone anytime. Does she have a certain date she wants me to call her? Or set up a computer? My case manager is right here beside me. You can speak to him.
Why don't we go ahead and mute and turn off your video, and I'll give you some contact information down in the chat, okay?
Okay, thank you.
Thank you. Amy, are you still on here somewhere? Yeah.
I am, Judge.
I sent Bonnie a link straight out of the meeting. Like the
Okay.
link of the ongoing meeting that is still going on.
Yes, Your Honor. I've sent it to her multiple times and she keeps sending me this picture, unable to rejoin this meeting. So
Oh, you know what happened?
no, what happened?
I never did turn I had those two, I had Powell County and Montgomery County both in the morning meeting because they were confused about the Eastern time and the Central time. And
I remember you saying that.
I never changed the meeting. So so when I removed them, once you remove somebody, they can't join back. I never terminated this meeting and started up the afternoon meeting. I just kept the same meeting.
Gotcha.
So
Okay.
I don't know that there's any resolution to that other than for me to stop this meeting and then redo it and have everybody rejoin. But I guess what I ought to do is just get everybody that we've got on here and deal with all the non-jail people and then stop this meeting and then start it back. I mean, the same link will work. Everybody can click on whatever link they want to
Yes,
and
Your
get back in. But now that I've got all of these non-incarcerated people in here, I don't want to send all them out and ask them to join back because that's too much trouble for them.
Yes,
You
sir.
see what I'm saying? But I'll have to end my meeting before she can join back into the meeting.
Yes, sir. I'll let her know.
So it looks like I got Mr. Tang on here. Maybe 1, 2, 3. Oh, hold on. She must have been able to use that link that I sent her because there she is. Tell you what, I'm a Zoom pro. That was sarcasm. In case anybody can't Zoom. All right, I see you, Bonnie.
Hey, Judge, I had to do it from my computer. My other one is not working.
Dang it. All right.
Technology.
It's a blessing and a curse.
Right?
All right. So I guess, Mr. Simpson, you've got an out of custody person and then an in custody person. So why don't we go ahead and take yours up?
All right, Judge. I can do Mr. Tang really quick.
All right. Wait, yeah, Mr. Tang, yeah, there you are. Okay.
We got an offer this morning from the Commonwealth Judge, and I need time to talk with Mr. Tang and evaluate that.
Yeah, I've got some ambient noise here that's interfering with my ability to hear you.
Can you hear me better?
I hear you a little better. Yeah.
Yeah, Judge, we got an offer this morning from the Commonwealth on Mr. Tang's case, so we need time to evaluate that.
What are you thinking?
Maybe sometime in late May.
Your Honor, I think that should be something that we should be able to take care of sooner than late May.
Okay, well, I'm going to be out next week, and then I've got a trial May the 11th that will last about a week, week and a half.
Can we do it in April, the 19th or the 27th?
Sure, 27th.
Okay,
Well, 26th.
sorry,
There, yeah.
my math is not working today, I guess.
One or 1:30,
Well, what we said April, right?
April 26th. Yes, sir.
Yeah, that'll be about, I mean, we still call it the 1 o'clock docket, but that'll really be 1:30 or, probably before we get to it.
All right. Mr. Tang, did you hear all that?
Yeah, I can hear fine. Thank you.
Okay, all right.
So then just you all, Mr. Tang, just be sure that you and Mr. Simpson can talk between now and then, okay?
Yes, sir. I understand.
All right, April 19th or 26th.
All right, Stephen, you can sign off now.
All right, got it. Thank you.
Thank you. And then the other person I have, Judge, is Michael Bruton, who's in custody.
Right. Mr. Bruton.
Yes,
Okay.
sir.
Mr. Bruton,
Yes, sir.
let's see. He's got the 2 cases on, right?
Yes, sir. He's
Yeah.
a state inmate at this point. Got 2 cases on, 20 CR 140 and 20 CR 242. I got an offer late Friday afternoon from Mr. Gardner. And have not had an opportunity to discuss that in any great detail yet. Talked to him about an hour ago.
Do you want to look at that same day for?
April 26th will be fine, Judge.
All right. We will get you down.
Thank you.
Thank you.
Mr. Bruton will be in touch. Thank you, Your Honor.
All right. Good luck.
All right.
Let's see. What else do I got on here?
Bonnie will be back in a second.
Okay, good deal. Let's see. Where'd you go? Mr. Driver, you have somebody in custody, don't you?
Who do you need?
Well, I don't know yet.
Oh, she's coming back.
He must be busy. What about Mr. Brown? Who do you have, Mr. Brown?
Good afternoon, Judge. I've got Amanda Nichols, and I see her on here.
Oh, yeah.
Amanda, can you, well, I guess, let me give you my number. I need to meet with Miss Nichols. I got this referral a week or 2 ago, and I haven't met with her yet. You have something to write with, Amanda?
Mr. Nichols, can you, you're on mute, so we can't hear you if you talk.
Okay, yes, sir.
All right.
So my number is 270-651-9000. Call and make an appointment with my secretary to meet with me as soon as you can.
Okay.
And what is your number? Do you have a contact number?
Yeah, it's 270-990-7994.
Okay. Is this your case, John?
It is.
Okay, yeah, she's got, Miss Nichols has 2 cases. I've got the discovery. If I could just have a brief continuance to go over it with Miss Nichols and have a chance to meet with John.
Yeah, I think we actually need to arraign her.
Oh, she hasn't been arraigned? Okay.
Yeah.
I think you might be right about in the 21 CR 66 case. That's the one that she hadn't gotten arraigned on, so we will take care of that.
Hey, Judge. We would plead not guilty and waive a formal reading in that case.
Okay. Super. I'm gonna note here, Mr. Brown, and this is a conflict case, right, Mr. Brown?
Yes, Judge.
All right. Okay, are you looking at April 12th? Let's do the 12th or the 19th.
I can't do the 12th.
Oh, yeah.
I can do the 19th.
So we'll do the 19th at 1 o'clock, okay?
And Judge, I think there's also 21 CR 67 as well. 66 and 67.
Yeah, the only case we've conflicted so far was the 409 case, so she does.
Oh, okay.
You're saying that Miss Nichols has 67?
Correct.
Oh, it's so, there's just nothing in it. It's so thin, I didn't see it. It's stuck to this other one. Yeah, here it is. Yeah, Mr. Brown, I'm sorry. She also has the aforementioned 21 CR 67. That's promoting contraband and first degree possession. So I'll just not do a not guilty plea on that one as well. Okay.
Okay, Judge. It looks like one of these is a Metcalf case. 2055. That's what I'm showing.
Yeah, the Metcalf, she does have a Metcalf case that we have just been kind of popping it along with the other case, the other Barron County cases, just out of convenience, if nothing else. So I haven't talked about that one yet, but I was planning on just moving it to the same day unless there was an objection.
None
So
here,
Denise,
Judge.
is Bruce going to represent her now in all of those cases?
Yes, I'm gonna have to officially conflict the 66, 67 because they were just a rain day. But I have already sent the Metcalf and the Barron 409 case to him.
Okay.
Yeah. So Mr. Brown, you've got 20 CR 409, 21 CR 66 and 67. And then I don't have the Metcalf County case right here with me, but yes, sir.
Yeah. Okay.
Yes, excuse me, we're just moving in.
So I guess Denise or John, whoever has it, can y'all send me the discovery on that? The 21, 66 and 67?
Yes, we will.
Okay, great.
All right. So I'll see you all on April 19th at 1 o'clock.
Okay, Amanda, just when you get off here, go ahead and call my office and make an appointment, okay?
Yes, sir.
All right.
All right.
That's all I had, Judge.
Thank
Thank
you.
Thanks.
All right, let's see. Bonnie, let's do Mr. Driver, you want to do your case? You've got Miss Paxson, right?
Yes, sir.
Yeah. Miss Paxson?
Okay, Judge, this is my motion. She has two separate cases, 21 CR 16, then 21 CR 338. And this is a motion to change bond to allow home incarceration. And the problem I've had of course, as I stated last week, I'd listed the bond incorrectly on each of these motions. Really, it's 25,000 per case, 10%. So it'd be 2,500 for each case, or a total of 5,000. She cannot afford to make that bond. I've had a really difficult time communicating with my client. She's been a poor historian as far as her medical history. And then additionally, you know, I have my own concerns about getting out and going to the jail. You know, that the jail's done the best job it could as far as preventing the spread of COVID, but you know, there's a lot of situations there where they have a high influx of people, of new people coming in and out of the jail. And personally, I don't want to put myself at risk. You know, I think, you know, it's going to be a while before a lot of attorneys will feel safe to appear in person in the jail. So it's really basically impossible for me to represent her. The Commonwealth has provided discovery. It's very difficult to sit down and talk to her about it. When she and I have talked about things over the phone, you know, I just don't feel that. I think it's almost impossible for her and I to communicate over the phone. She does not appear to understand, you know, certain things I'm saying. And I think it's a situation where I'm going to have to sit down and go over documents with her. As far as the public is concerned, you know, these allegations were made with the second offense when she was already out on bond for the first, but we've got a situation where her home life is going to provide, aside from the house arrest, and I didn't include this because I learned this after the fact, her mother, Cindy Stroop, is residing in her home 24/7. She has Brittany has a 14-month-old daughter who she's not been able to take care of because she's been in jail so long. And, you know, as we all know, it's critical during that time of infancy for the mother to be caring for her child. And instead, her mom's having to do it, but her mom will be residing in her residence. So if there's any concerns, there shouldn't be. It's going to be her mom, and then her husband will be there, and then effectively the man who's been pretty much her stepfather for several years will be residing there also. So you've got her mom that's there 24/7, two other adults. I've talked to Julie Adkins, you know, she's confirmed. I mean, if Brittany were to even attempt to remove the ankle monitor, it would send off an alert. So I don't think there's any fear of that. If the court wanted to add another restriction that Brittany not be allowed to operate a motor vehicle without the presence of, you know, either her husband, her mom, or then her mom's basically boyfriend. What's his name, Brittany?
Leonard Blessings.
Yes, Leonard. So, I mean, I should have included that in my motion, but I just make that orally now. So I feel that effectively, you know, there's no harm or there's no risk to the public under these sets of circumstances, and she needs to get out to help in her own defense. Thank you, Judge.
Judge, as far as the Commonwealth's argument.
I apologize. I had to unmute myself.
No, I understand. It's the same argument we've made, you know, previously in these cases. Ms. Paxson is currently in on 2 Class B felonies, and she does have a 10% bond in each one of them for a combination of $5,000. We believe that's an appropriate bond considering the circumstances, and also considering the circumstance that she was previously on bond when she committed the new offense. I understand Mr. Driver's argument, but the bond violations that she had previously, I guess, would not be prevented just by home incarceration. I mean, she could commit the acts while still in her house in this situation. So obviously the court has discretion of this bond, but the Commonwealth would be opposed to any modification.
And Judge, if I could just respond briefly, and
Yes.
that's why we try to structure this in such a way to, of course, she's denying the allegations, but we're trying to structure this in such a way where, she can help in her defense. She would only be allowed to, if she had a doctor's appointment or to meet with her attorney or whatever, very limited situations, U-turn would place on her to leave her home. And then when she leaves her home, she's going to have another adult with her. So, that would be a restriction. So, I feel that it's appropriate and it's needed in her situation, specifically, really to help me try to defend her.
Tell you what, let's, I know that there has been, both of these indictments have come down. It's been a minute since I've looked at everything in these because just the time that's gone by. But Mr. Driver, I'll have to take these motions into under advisement because I don't really know what the appropriate thing is for me to do. But I'm going to take a look at them and see. And then what we'll do is I'll go ahead and set her pretrial on for, maybe in May sometime, just to give a little bit of time so that, either in the event that I change that gives you all more time to talk. In the event that I don't, that does give you, just more time going by, and maybe there'll be, things will change to where it's more palatable to go down there. I don't know yet. But either way, a little bit of time ain't gonna hurt on either situation. So we can look at May the 17th. You wanna do that?
Could we do it a little bit earlier just in case, like maybe May the 3rd?
We can, yeah. All right, that's what we'll do.
Okay, so we've got another pretrial on May the 3rd at
May 3rd at 1 o'clock.
Okay, thank you, Judge.
And that'll be yeah. All other things being equal, if people are not in custody in the Barron County Jail, and this is for everybody that's listening, that will be in person. And we won't be Zooming at that point. We'll be all the lawyers and everybody will be up here in person. Okay.
But then, Judge, but you're still taking the motion under advisement, and then just for Mrs. Paxton's clarification, then you may rule on that prior to May the 3rd.
Oh, I fully intend to rule on it prior to that date.
Okay. All right. Thank you, Judge.
All right. Thank you.
Thank you, Judge. Bye-bye.
All right. Danielle Cowan.
Judge, we have a deal in that. Josh sent me the plea docs earlier when we started, and I filed them and also sent a copy to Chrissy to print out. And I also CC'd you.
Yep, I saw those, and so did she, because she printed them out. Here they are. All right. Is Mr. Spears, is this you?
Yes.
All right. Can you get you up here? All right. Ms. Cowan, correct?
Yes, sir.
Can you raise your right hand, please? You swear or affirm that you will tell me the truth, so help you God?
Yes, sir.
All right, thank you. All right, hold on. It looks like I've got copies of all this stuff. Figure out what's been signed and what hadn't. these, and if we don't need them by the time I get done, throw them away. All right, Ms. Cowan, we're back. Let me talk to you about these cases. The first one numerically is 21 CR 07. There is a motion to enter a guilty plea in that case, and it is right here. Does that look familiar to you?
Yes.
All right. There is a signature page. Is that your signature?
Yes, it is.
All right. Thank you. This is the Commonwealth's offer on a plea of guilty. Does that also look familiar to you?
Yes.
Okay. There is the signature page. Does that have your signature on it?
Yes, it does.
Okay, thank you. Now, while we're at it, let's just go ahead and look at this second case. There's also a motion to enter a guilty plea in that case, and it looks like the same signature. Is that your signature?
Yes.
Thank you. Here's the offer from the Commonwealth. Is that your signature?
Yep.
All right, thank you. So you look over all of these documents before you signed them?
Yes, I did.
And did you have all the time you needed to consider what you were signing, to discuss and ask questions with your attorney and so forth?
Yes.
Are you satisfied that you've had enough time to do all of that?
Yes.
All right. Do you believe that you understand the contents of the documents that you've signed?
Yes.
All right, Ms. Cowan, do you understand that you have the right to not to incriminate yourself? Sometimes that's called the right to remain silent. If you plead guilty, you are waiving that right.
Yes.
All right. You have the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. You can confront and cross-examine the people that give testimony against you, and you can put evidence on in your own defense. You understand that you waive those rights if you plead guilty.
Yes.
You understand that you waive the right to appeal if you plead guilty.
Yes.
All right. Thank you. In the 21 CR 07, possession of a controlled substance, first degree, first offense, that's a Class D felony. On a plea of guilty, the Commonwealth's recommending a sentence of 1 year. Possession of drug paraphernalia, Class A misdemeanor. On a plea of guilty, the Commonwealth's recommending a sentence of 12 months. The 1 year and the 12 months are running concurrently with one another for a total of 1 year. Commonwealth opposes probation. The sentence would run concurrently with the case that we are getting ready to talk about. Is this what you believe the offer from the Commonwealth to be?
Yes.
All right. Other than what I just told you, have you been promised anything to get you to plead guilty?
No.
Are you pleading guilty voluntarily?
Yes.
Do you feel like your judgment is impaired for any reason?
No.
Do you feel like you're under the influence of anything?
No.
All right. Has anybody threatened you to try to make you plead guilty against your will?
No.
Ms. Cowan, are you acknowledging that on October 1st, 2020 in Barron County, Kentucky, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes.
Okay. I'm going to accept your plea of guilty in that case, and then we're going to move on to your next one, which is 21 CR 27. In that case, the Commonwealth has made the following offer. Count 1, trafficking in a controlled substance, first degree, under 2 grams, first offense. That is a Class D felony. The Commonwealth agrees to recommend a 3-year sentence. Count 2, drug paraphernalia, a misdemeanor. The Commonwealth agrees to recommend a 12-month sentence. Count 3, disregarding a traffic control device. And count 4, failure to or giving an improper signal. Commonwealth agrees to dismiss those. The total recommended sentence would therefore be a 3-year sentence. The Commonwealth again opposes probation. I'm sorry. There is items, cell phone, et cetera, that were confiscated at the time, seized at the time of the arrest, and those would be forfeited. The time in this case and the time in the case we just talked about would run concurrently with one another. Is this what you thought you were agreeing to in 21 CR 027?
Yes, sir.
Other than what I just told you, has anybody promised you anything to try to get you to plead guilty?
No,
Has anybody threatened you?
no,
You pleading guilty voluntarily.
yes,
Ms. Cowan, are you acknowledging to me that on or about December 26th, 2020, in Barron County, Kentucky, you knowingly and unlawfully possessed under 2 grams of methamphetamine and you possessed drug paraphernalia?
yes,
Oh, I'm sorry. And you possessed that methamphetamine with the intent to sell, distribute, or transfer it?
yes,
All right. My apologies. I left that part out by accident. All right. So I'm going to accept your plea of guilty in both cases. Mr. Spears, are we going to set this over for a PSI and sentencing?
Your Honor, we've discussed it and she waives PSI and malicious be final sentence today.
All right. Miss Callan, that's what we'll do. Having accepted your plea of guilty in each case, I will sentence you to the agreed upon amount of time in each case. It'll run concurrently. The total sentence across both of the cases will be 3 years. You will serve out any fines and court costs. Okay?
okay,
You have any questions?
no,
All right, ma'am. Good luck, okay?
thanks.
Excuse me, Judge.
Hello? Talking to me. Hello? Yes. All right. Bonnie, let's talk to, I don't know who you all want to talk to. We're just doing alphabetical, I guess. Mr. Denton?
Judge, Mr. Spears and I, guess he's not up here yet.
Bonnie, can you hear me?
I can, Judge.
Mr. Denton?
He's coming.
All right, thank you. Yeah, before we, Ms. Gardner, before you tell me that, let me also point out that one of these is an indictment. I don't believe I've arraigned him yet. It's 21 CR 74. So before we get out of here, I'll have to do that. All right, go ahead.
If you want to go ahead and arraign him, we've been talking back and forth about all 3 cases. I don't think we have an agreement at this time. So if you wanted to go ahead and arraign him on that new case and set a pretrial on all 3.
All right, Mr. Spears?
Yeah.
Mr. Denton's got a new, I guess you're aware of it, right? He's got a new indictment charging him with possession of a controlled substance, 1st degree, 2nd offense, possession of drug paraphernalia, possession 3rd degree, and DUI 2nd offense aggravated.
I think I caught, yeah, I mean, I know about the case, Your Honor, but there's some background interference that I couldn't quite understand everything you said. There we go.
Yeah. How about now?
There we go. I can hear you now.
Possession, count 1, possession 1st degree, 2nd offense. Count 2, drug paraphernalia. Count Count 3, possession 3rd degree. Count 4, DUI second offense aggravated.
Yeah. Your Honor, we waive formal arraignment, enter plea not guilty, and request pretrial conference and discovery.
All right. When are you asking me to put your pretrial on for?
Right now, Your Honor, can we put it on like April 19th or the 26th?
Either's fine, Judge.
Okay. Yeah, I mean, I'm not beholden to either one. Let's do the 19th.
Okay.
One o'clock.
And Your Honor, as Risa stated, we do not have an agreement in these cases as of right now. I at this time, and I've made Risa aware of this, at this time I was going to ask that ask for, he got his bond revoked in the other 2 cases about, I think, a month and a half ago. I was going to ask the court to consider reinstating those bonds. He is willing to wear an ankle monitor, and as well, Your Honor, his family has arranged for him to go to a long-term treatment facility, I think in Williamsburg, Kentucky. I've talked to Bethany about it. She's talked to them as well, and it's a year-long program. And so I would ask that the court consider reinstating his bond and allow him to go to that rehab facility while we try to work out these cases.
Already been accepted, Judge Alexander. I really appreciate it.
Okay.
And I have a bed letter that I've sent to Ms. Gardner. I'll send to you as well, Your Honor.
Okay, yeah, that'll help. All right, Ms. Gardner.
Judge, we would oppose it. Mr. Denton has 3 pending cases, one of which dates back to 2019. And he has gotten the most 2 recent indictments while he was on bond for that. The last one, he was charged with DUI. All of them involve drug use. The first one includes a fleeing and evading. The second includes a resisting arrest. I think that those charges demonstrate that he's going to have a hard time complying with what's required of him. He's had a hard time staying out of trouble, and the DUI especially, I think, suggests he's a danger to the community. The offer we made is not for probation. We are opposing probation. I'd ask that he remain in custody at least until the next pretrial date.
All right, I understand. Mr. Spears, I'll wait till I get your letter and then I'll review that. You already sent that to the Commonwealth, right? So they've seen it.
Correct.
Right. Yeah. So I'll consider what you're asking after I get that letter and get some confirmation of what's going on. Okay.
And I guess, Judge, with regard to that treatment, obviously, you know our position, but I would hope that this wouldn't be something that would prolong these 3 cases another year, that we couldn't resolve it.
From what I've been told, Risa, he can attend court and either via video or in person. So
okay. All right. Thank you.
Yeah. 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 I mean, I don't think anybody would want to, I mean, there's kind of 2 schools of thought here, and I'm not sure that anybody would want to just put it off for no reason. But of course, if he goes to treatment and ends up successfully completing it and learning what he needs to learn there, it wouldn't technically be for no reason. It'd be for a pretty good reason, because it would help him out, I think, going forward with the rest of his life. So, we'll think about it. All right.
Appreciate it.
All right. Thank you.
All right.
I know you all don't want to break, but I'm going to have to take about 5 minutes and come right back. Okay. So hang in there, everybody. Bonnie gonna take 5.
Okay, Judge.
Have I been going 15 minutes? 5 minutes, I mean? I'm back.
Hello?
All right, I'm back, Bonnie.
Judge?
Are you talking to me? April,
This is my house. You go home.
are you talking to April DeRogi?
Hello?
What? I don't know who keeps yelling hello, but I don't know who I've got. Who do I have?
This is James Houchins. I think I've lost my connection on my camera.
All right, what are you?
My Wi-Fi, I've lost my Wi-Fi.
Are you calling from a telephone?
Yes, I've been here during the whole meeting.
That's my client, Your Honor. We'll get you in just a minute, James.
Okay, I'm sorry. I didn't know what to do here. What can I do to get back on?
I don't know.
Your Honor, I don't know if it's just easy. Mr. Bell and I have not had any conversations about this case. I would imagine he'd be asking for another pretrial. If it would just be easy to go ahead and set a date. I think he was supposed to get me a counter offer. I still need that, Mr. Bell.
That's correct, Your Honor.
When do you want to come back?
Your Honor, I mean, if 30 days is not too long, if we should don't object to that.
That's fine.
April 20. Well, you want to do May 3rd?
Yes, sir.
That'll be live.
Yes, sir.
May 3rd?
Yes.
Yep. Okay, thank you.
Johnny, are you there?
Yeah, James, we set you for May the 3rd, so you're free to go.
Okay, I've got a real bad connection.
That's fine. I'll just call office and I'll talk to you.
Okay, do I log out of this or?
Yeah, just hang up. You're good.
Just
to
hang
go.
up.
Oh, okay, thank you, Judge.
All righty. All right. Think we're ready to do Mr. Guess.
Judge, on Mr. Guess, Ms. Myers and I have talked back and forth on this, and I think we're pretty close to having a deal in this, but I had to consult with the victim's attorney, and I hadn't heard back from him. I was going to suggest, I know we're not in court next week, but to put this back on in 2 weeks. Once I'm able to talk to them and get their input, I think we would be pretty close at that point to wrapping up all 4 cases.
Okay. So we need to go something like April 12th.
Whatever that first Monday is after we get back. I think that's April 12th.
Yep, that's April 12th.
Okay.
Mr. Guess, I'm gonna put you over to April 12th. Okay, can you hear me?
Yes, sir.
Okay. I just wasn't sure because you all are on a different device there than what you're normally on. Your attorney will be talking to you, okay?
I get like every third word. I'm getting like every third word.
Okay. We are going to put your hearing over to April the 12th at 1 o'clock.
Yes, sir. Any chance of me getting out before then?
Do
Think I
what?
can be released before then? Think I can get released before then?
The odds are against it.
Oh, Lord, I'm going back to my cell. Thank you, sir.
All right.
We'll come back. Close enough in a woman months. I'm ready to go back to my cell if you want to call.
Jennifer Huff. Oh, never mind.
Judge, in this case, discovery's been provided and the offer's been provided. I haven't gotten a response from Greg on the offer.
I sent a counter offer last Friday,
You did?
Thursday or Friday. It was in with that, another one I sent. I'm trying to remember who the other one was. I can't think of his name right now.
I apologize. I obviously overlooked that, so I will get back with you on it.
Okay. There was another one in that also, and I'm not on Mr. Smith, David Smith. And I hadn't heard back from you on him either, so you may have just not seen those two in with that email.
We'll go to April 12th.
Okay, Judge.
What was the offer?
Well, we're not gonna talk about that
Okay,
on the record. I mean, you and your attorney need to talk about that when everybody's not listening, okay?
oh, okay.
All right. All right, thank you.
All right, thank you.
Joseph Jewell.
I'm short, mine is there.
All right, Mr. Jewell, how are you?
Good, how are you?
I'm doing all right. Can you hear me okay?
Yes, I can.
All right. Can you raise your right hand? Do you swear to tell me the truth? So help you God.
Yes, I do.
All right, thank you. Jewel, take a look at this. If you don't care, take a look at this document right here. Does that look familiar?
Yes, sir.
Is that your signature?
Yes, sir.
Okay. How about this one?
Yes, sir.
Is that your signature?
Yes, sir.
Okay. Did you read over both of these things before you signed them?
Did.
Did you have the opportunity to discuss them with your attorney and to ask him any questions that you might have had? All right.
I did.
All right. Do you feel like you are under the influence of anything today?
No, sir.
Is your judgment impaired today for any reason?
No, sir.
Okay. Mr. Jewell, do you understand that you have the right to remain silent? Sometimes that's referred to as the right not to incriminate yourself. If you plead guilty, you waive that right.
Yes, sir.
You understand? Okay. You have the right to a trial by jury where the Commonwealth would have the burden of proving guilt beyond a reasonable doubt. You understand that you waive that right if you plead guilty.
Yes, sir.
You understand that you waive the right to confront and cross-examine the people that give evidence against you, as well as the right to put evidence on in your own defense if you plead guilty.
Yes, sir.
And finally, do you understand that you waive the right to appeal the outcome of your case to a higher court if you plead guilty?
Yes, sir.
All right, thank you, Mr. Jewell. In this case, the Commonwealth has made the following offer to you, and I just want to make sure you and I both understand it. Count one, possession of a controlled substance, first degree, second offense. That's a Class D felony. The Commonwealth recommends a 2-year sentence on a guilty plea. Count two, possession of drug paraphernalia. That's a Class A misdemeanor. The Commonwealth recommends a 12-month sentence on a guilty plea. Count three, expired or no registration. Commonwealth will agree to dismiss that on your plea of guilty to the other 2 charges. The Commonwealth agrees to probate. It will be a 2-year sentence, and the Commonwealth agrees to probate that sentence for a period of 3 years. The sentence would be consecutive with any prior sentence. The probation would be conditioned on you complying with the rules given to you by probation and parole, and specifically would require you at their direction to get an assessment for substance abuse and to comply with any recommended treatment, after that assessment. Okay?
Yes, sir.
Is this what you understood your agreement to be?
Yes, sir.
Okay. Other than what you and I just talked about, have you been promised anything to try to get you to plead guilty?
No, sir.
Have you been threatened by anyone to try to get you to plead guilty?
No, sir.
All right. Are you pleading guilty today voluntarily and of your own free will?
Yes, sir.
Okay. Mr. Jewell, do you feel like you're under the influence? Did I ask you that already? You feel like you're under the influence? Okay.
No, sir.
All right. So do you feel like I'm making you plead guilty?
No, sir.
Okay. Are you pleading guilty, Mr. Jewell, because you acknowledge that on December 28th, 2019 in Barron County, you knowingly and unlawfully possessed methamphetamine, having a prior conviction for possession of a controlled substance?
Yes, sir.
Are you also acknowledging that at that same time and place, you possessed drug paraphernalia?
Yes, sir.
All right, Mr. Jewell, I'm going to accept your plea of guilty today. And Mr. Spears, what does Mr. Jewell wish to do, assuming you all have discussed it on his sentence?
He wishes to waive PSI and be sentenced today.
Mr. Jewell, that doesn't seem like a crazy idea under the circumstances. So I'll go along with it. So I'm going to sentence you in accordance with the agreement that you just reached. I will waive on the basis of indigency your fine and your court costs, and I will grant your request for probation under supervision of probation and parole. We have a probation officer on here that is going to want to talk to you about what you do when you get out. But I can tell you that what they're going to want you to do is get in touch with them, and you don't want to fall off on that. Okay. You want to do what they tell you to do. Okay. Officer Mann.
Yes. Mr. Jewell, do you have a good phone number that we can use to get in touch with you?
Yes, 646-270-646-6733.
6733?
Yes.
Okay. And what's your current address?
1255 Glasgow Park City Road.
Okay. Upon your release, I need you to call the probation office. You can look that number up on Google, or I can give it to you now. It's 270-678-7443. Okay.
Thank you.
Thank you.
All right, Mr. Jewell, your odds are you'll be getting out, today. I don't know, looking at the time, you probably want to be sure you just call them first thing in the morning.
Okay.
Because I doubt by the time you get out and get to a phone and all that stuff, it might be 5 or 6 o'clock and they won't be, you can call anyway, but
okay.
If you don't get anybody today, you better call first thing in the morning. Okay.
Yes, sir.
All right. Do you have any questions?
Sure. No, thank you, sir.
All right. Good luck this time. All right.
Thank you.
You bet. Y'all ready? Let's see. Mr. Spears, you ready for me to call Mr. McCandless?
Yes.
That was a wholehearted endorsement of my plan. He didn't just like beat around the bush or anything. He was, yes, I am ready. All right. I like the enthusiasm.
Judge, you only have plea documents in 2 of the cases. I'll be dismissing the case involving the escape upon completing in these other 2.
Oh, okay. Okay.
So I'll submit an order or a motion and a proposed order to you tomorrow. If that
Perfectly
works.
fine. That's perfectly fine. Mr. McCandless, can you hear me?
Yes, Sean.
They
Yes,
are.
I can hear you good.
Do what?
I can hear you. Yes, sir.
Okay. Can you raise your right hand for me? Do you swear to tell me the truth? So help you God.
Yes, Sean.
All right. Thank you.
Thank you.
So let's go through these.
Perhaps my able is good or not.
That's about all I drink.
What am I here? Are there people?
Can you see yourself?
Jody, are there people in there talking where you are?
Guys, quit talking.
Yeah, I can't. I'm having a lot of trouble because I can hear them better than I can hear you, which is the way acoustic things seem to work out. All right. Mr. McCandless, I got 2 cases here that they tell me you've got an agreement in where you're pleading guilty, and then one that they're going to agree to dismiss if you plead guilty on those other 2, right?
Yes, Your Honor.
All right.
Yes,
This
sir.
is, This is a motion to enter a guilty plea. Does that look familiar?
Yes.
All right. This is the signature page. Is that your signature?
Yes, sir.
Thank you. This is the Commonwealth's written offer. Does that look familiar?
Yes, sir.
And this is the signature page. Is this your signature?
Yes, sir.
Thank you. On the other case, it looks like the same signature, but this is the motion to enter a guilty plea. Is that your signature?
Yes, sir.
And this is the offer. Okay.
I was trying to. Yes, Your Honor.
And this is the signature.
Yes, sir.
All right. So did you read all these things before you signed them?
Yes, I did, Your Honor.
Did you have time to talk to your attorney about them?
Yes, sir.
All right. You have plenty of opportunity to ask him questions if you needed to.
Yes, sir. I had one question that I did see on there, but he said he's pretty sure that was my time. They did 20%. I mean, I didn't see it on the forms.
Oh.
I know it was offered last time.
Josh, which case was that? Is that the?
I can't, if he's just asking if he'd serve at 20%, which I'm pretty sure everything would be.
Yeah, I mean, he doesn't have any violent.
Yeah, it's no violent offenses, so.
Yep. Well, and just to be on the safe side, let me point out to you that the reason that isn't on the offer is because the Commonwealth, or really for that matter, the court doesn't dictate how much of your sentence that you serve. Those are questions of statutory law and then of course probation. they're called indeterminate sentences because we just give a sentence of a certain amount of time and then you don't necessarily serve that amount of time. You oftentimes serve less, almost always serve less, but that is not determined by us. That's determined after you get sentenced, you know?
Yes, sir.
All right, all right. So Jody, do you understand that you don't have to plead guilty? You've got the right to remain silent.
Yes, sir.
All right. If you do plead guilty, you waive that right. Do you understand?
Yes, sir.
Okay. You've got the right to have a jury trial where the Commonwealth would have to prove guilt beyond a reasonable doubt. You can confront and cross-examine witnesses. You can put evidence on in your defense. You understand that you waive those rights if you plead guilty.
Yes, sir.
All right. You have the right to appeal and you waive that right if you plead guilty. Do you understand?
Yes, sir, I do.
Oh, okay. Do you feel like you are under the influence of anything today?
No, sir.
Is your judgment impaired for any reason today?
No, sir.
All right. Mr. McCandless, in 19 CR 548, the Commonwealth has made the following recommendations. Count 1, trafficking in a controlled substance, first degree, under 2 grams, first offense. That's a Class D felony. On a plea of guilty, the Commonwealth would recommend a 5-year sentence. Count 2, possession of a controlled substance, 3rd degree. That is a Class A misdemeanor. The Commonwealth would recommend 12 months. Count 3, endangering the welfare of a minor. Count 4, possession of drug paraphernalia. Count 5, possession 3rd degree. Those are all Class A misdemeanors, and the Commonwealth recommends 12 months on a plea of guilty to each one. They will all run concurrently for a total of 5 years. The items seized at the time of the arrest would be forfeited. The time in this case and the time in the case that we haven't talked about yet, but we're fixing to, would be concurrent with one another. And the Commonwealth opposes probation. Is this what you understand the offer to be?
Yes.
All right. Other than those promises that I just read to you or just discussed with you, have you been promised anything to try to get you to plead guilty?
No, sir.
All right. Are you pleading guilty voluntarily today and of your own free will?
Yes, sir.
Do you feel like you are threatened by me or anyone else to try to get you to plead guilty?
No, sir.
Mr. McCandless, are you acknowledging that on June the 26th, 2019, in Barron County, you knowingly and unlawfully possessed an amount of methamphetamine less than 2 grams with the intent to sell, distribute, dispense it, or transfer it?
Yes, sir.
All right. Are you also acknowledging that at that same time and place, you knowingly and unlawfully possessed alprazolam, gabapentin, and drug paraphernalia?
Yes, sir.
All right. And finally, Mr. McCandless, are you acknowledging that at that same time and place, you committed the offense of endangering the welfare of a minor when being a person legally charged with the care or custody of a minor, you failed or refused to exercise reasonable diligence in the control of the child to prevent him or her from becoming neglected, dependent, or delinquent?
Yes, sir.
All right. I'm going to accept then your guilty plea in that case. Wrong one. And I'm going to move on to, tell you what, that's the one we're going to, unless we think we need it, they're going to tender an order. Yeah. All right. All right, Jody, I'm going to move on to this next one. You have been offered the following in this case. Count 1, engaging in organized crime or criminal syndicate. That is a Class B felony. The Commonwealth has agreed to recommend a sentence of 10 years. Count 2, 3, 4, 5, 6, 7, and 8 are co-defendants because this was a multi count multi-person indictment. Count 9, trafficking controlled substance, first degree under 2 grams, first offense. The Commonwealth agrees to recommend on that Class D felony a 5-year sentence. Count 10, 11, and 12 are co-defendant counts. Count 13, trafficking controlled substance, first degree, over 2 grams, first offense, enhanced by possession of a weapon. That is a B felony. The Commonwealth agrees to recommend a 10-year sentence to that, on that charge. The 10-year sentence in count 1 and the 10-year sentence in count 13 would run concurrently with one another. The 5-year sentence in count 9 would run consecutively with the 10-year sentence in count 1. Therefore, when the dust settles on this, the total recommended sentence in 19 CR 565 would be a 15-year sentence plus forfeiture of items seized, and the Commonwealth is opposing probation. Mr. McCandless, is this what you believed the offer to be in this case?
Yes, Your Honor.
All right. And other than that, those promises, did anybody promise you anything to try to get you to plead guilty?
No, sir.
Have you been threatened to try to make you plead guilty?
No, sir.
Do you feel as if I am making you plead guilty?
No, sir.
All right. Mr. McCandless, are you acknowledging to me voluntarily and of your own free will that on or during a period of time from February 15th to May 21st, 2019 in Barron County, Kentucky, you committed the offense of engaging in organized crime when with the purpose of establishing or maintaining a criminal syndicate or with the intent to facilitate any of the activities thereof, you committed, conspired, or attempted to commit, or acted as an accomplice in the commission of trafficking in a controlled substance in which a criminal syndicate was engaged on a continuing basis.
Yes, sir.
All right. Are you also acknowledging that over that period of time, you knowingly and unlawfully possessed an amount of methamphetamine less than 2 grams with the intent to sell, distribute, dispense it, or transfer it?
Yes, sir.
And are you also acknowledging that you committed at that same or over that same time span the offense of trafficking first degree more than 2 grams when you knowingly and unlawfully possess 2 or more grams of methamphetamine with the intent to sell, distribute, dispense it, or transfer it while possessing a firearm?
Yes, sir.
All right. Mr. McCandless, I will accept your plea of guilty today. Mr. Spears, how would you all like to proceed?
Judge, Mr. McCandless has 2 requests. First, he would like to be final sentenced at a later date and have a PSI done.
Okay.
And along those lines, Mr. McCandless has asked me to ask the court to consider furloughing him only for 24 to 48 hours to allow him to get some affairs in order before he starts this sentence. Just a day or 2 days just to get some stuff in order, and he'll go right back to jail. He does understand, I'll put it on the record to make sure he hears it again, that he understands if he does not come back to the jail after this furlough, if it's granted, that this deal will probably not be off, and that he needs to return when he's supposed to return, and so we can have final sentencing and it still stays intact.
Okay. Who do we
It's my case, Judge.
Lisa, yeah, I'm sorry.
It's okay. I can't agree to that, considering one of these 3 cases was when he was out on bond. for the 2 previous cases, and he failed to return to custody. He faces a lot of time, and it's just hard to trust Mr. McCandless when he's already shown that he's failed to return to the facility after a furlough.
Well, you know, that is troublesome. I've talked about this before, and I mean, you know, not that I want anybody to, I guess I want you to understand my position, but it's, you know, we've tried this 2 or 3 different times here recently, and I guess one of them, we don't know yet whether it's going to work or not. The other 2 people didn't come back. And I mean, it's all well and good for them to swear to me they're not going to come back, but they didn't come back. And I mean, until they get got, which they will, but until that happens, I mean, they're in the wind and they're not serving their sentence that they both already had final sentencing come and go, and they didn't come back. And I don't know where they are. And they've both got a huge, big pile of, you know what, coming at them because their sentences are not going to be, you know, what the sentences are not going to be what they would have been otherwise. But still, despite that, I mean, despite everything they knew, they still did it. So it's a little bit, you know, I want to evaluate all of these on the merits of their individual petitions and not on the fact that the last couple of dummies that I let do it, you know, kind of bad appled the whole bushel for everybody else. But even at that, as Ms. Gardner pointed out, I mean, one of these escape cases is based upon a not coming back from a furlough.
Yes, sir.
And I understand they're going to dismiss that. I understand that's part of the representation of the Commonwealth is that's going to be dismissed. But you know, I can't unring that bell, I guess. Mr. Spears, let me set his final sentencing. You know, I might consider, you know, something that's that brief. I'll just have to see if I can get in a place where I'm willing to do it, because it's not worked out too good.
And Your Honor, I think that I'm going to have to hold on then to that motion, just, you know, as an incentive for that order to dismiss that case.
I can't, I'm not in the business of giving the Commonwealth advice, and you all are in the business of taking it. But I wouldn't file a motion to dismiss it till we got to the final sentencing.
Okay.
You know, on the basis of that, I mean, you know, I guess if I entered an order between now and then and I didn't agree to let him out, you could do it then if you wanted to. But you know, that's a good point, and I'm glad you brought it up. Let's set this sentencing for I guess we can do May the 3rd at 10. All right.
All right.
And I asked a quick question.
You know,
I didn't understand.
Yeah, go ahead.
On that time, was all that run together for a total of 15 years consecutive?
Both cases are concurrent.
Yeah.
For a total of 15.
The total amount of time across the 2 cases is 15. Is that what you're asking?
Yeah.
Yeah. Yeah. The first case that we talked about is concurrent with the second case that we talked about. Okay?
Okay.
Good deal. All right. Thank you.
Thank you. Thank you.
Rolling in here, hot chocolate. Cause trouble. All right. I'm up to Mr. Smith.
Your Honor, John had to leave early and I'm handling his cases for him.
I believe this is the one, Greg, that you said you thought you might have sent John a counter and he didn't see it.
I did, and I sent it to him again. He just said he's overlooked it when it was in an email on another case, and he just didn't catch it. Anyway, he sent me his answer on that, but I need to go over it with David and get his approval on it.
All right. You want to go to April 12th?
Okay. That's fine.
Is that enough time?
Oh, yeah, it is.
All right.
May 3rd.
Hey, Bonnie,
Yes, Judge.
where'd Mr. Smith go?
He wasn't done with you. Sorry, Judge, he thought you was done.
Well, I had my head down and I was writing and I didn't, I saw him for just a second. I just wanted to make sure he was still there and heard what we were saying.
April 12th.
Correct, sir. 1 o'clock.
Yes, sir.
All right. Thank you.
Judge, can I bring something up we said earlier on April 19th? Philip Kirby.
Yes.
He was one of them over in Powell County, and I forgot to bring it up. I won't be here on that Monday.
On which day was it?
April 19th.
All right. Which defendant was it?
Philip Kirby.
Okay. Let's just move it to the 26th.
Okay.
What we might want to do is a special, like an OTA on it, because I don't want him to think that he's losing his mind by not hearing it right or whatever. And Greg, you guys are gonna have to keep me on my toes, setting things on this whatever it is, May 10th or whenever it is that I just found out you all aren't gonna be available for.
I'll forget it quicker than anybody. Okay.
Well, I know that you have to do your training and all that stuff. I mean, it's gonna be kind of tough. That's the second day that we're having live court for the first time in 7 months. So, but anyway, it is what it is.
I'm always complaining they keep setting stuff on Mondays and Tuesdays, and that's the worst day they could do it.
I mean, that's probably what out of the 120 counties, I'd guess probably at least 100 of them, that's when they do a whole, at least district or circuit, if not both.
I know.
Well. Why they don't ask us.
Nobody me, that's for sure.
Yeah. Mr. Vibert?
Keep out there.
Hello, Your Honor.
Good afternoon, sir.
Good afternoon, you too.
Judge, I'm covering this for John, and believe he and Xander are still negotiating, and that he emailed an offer to her this morning.
That's correct. I did get an offer this morning that I think Mr. Vibert may actually want to take. My question though, Your Honor, I don't want him to necessarily be put off till April 12th, but I don't have enough time. I didn't have enough time this morning to get down to Barron County to the jail to see him to take any paperwork. Will you be available anytime this week by chance to where maybe we could set something very quickly if he does want to take this plea offer? Because the plea offer that I have actually would kind of resolve the case well prior to April 12th. And I hate to do that and tie you up on a second court date through the week, but I was just thinking I might actually be able to get this resolved with the new offer that I received from John.
And Judge, I was going to ask you on an unrelated Rocket Docket matter, if there may be time this week for someone that I think that we can resolve, but would be going to treatment before we were able to get back to court. Julie is talking to him about inpatient rehab.
We-
So if I
we
could piggyback on.
We could probably do something on Thursday morning. You know, I'll be tied up all day Wednesday. I've actually got a court trial, which you're gonna have to help me remember because we have to tell court security. Those people are coming in here live. Unless, I guess we better check with PAC, but they wanted to do it. They want to do it live. And then I'll be out that afternoon because we have our project development board that afternoon. But Thursday morning ought to be okay.
That would work. That gives me enough time to get down there and take him some plea paperwork if John can draft it up and go over it with him. We might be able to resolve everything Thursday.
Can Bonnie, or can you hear me?
I can, Judge.
You don't have court with anybody on Thursday morning, do you?
No.
Can we do 8:30 on Thursday morning?
That works for me.
Bonnie, we'll send you a link with, but right now sounds like it'll be Mr. Vibert. And I don't, if anything else popped up, Risa, or if any of you all wanted to throw anything else on there, just because if something worked out, some of these that we've put off for 2 weeks, but if something happened to work out, if I'm going to get on and take a plea from him, it might as well take 2 or 3.
Okay. I should have at least one more who's in custody for Thursday too.
All right, super. Good deal.
Thank you, Your Honor.
All right, you're welcome. Mr. Bibbert, I'll see you Thursday morning, okay?
I guess a bond reduction would be out of the question, sir?
I'm sorry?
Okay, thank you. Sorry about that, Zadie. Thank you,
Eddie,
ma'am.
I'll come down and talk to you probably either Tuesday night or Wednesday night, okay?
Okay, thank you, Miss Eddie.
That is April 1st, but I'm serious. All right. Let's see. Bonnie, who else do I have in custody down there?
I've got Scotty Udi.
Gotcha. Yeah. All right. Who's gonna, Mr. Spears, are you going to, or Greg, or one of you all gonna stand in with him? Or sit in as the case may be? It's a rocket docket.
Oh, okay, yeah, I can do that.
All right.
You didn't say yes, did he?
All right. All right.
Some reason.
Mr. Judy, how are you?
Wonderful. How are you doing?
Yeah, well, shoot, you're doing better than I am. They tell me you've got some agreements here.
Yes, sir. Finally.
Okay. Bear with me and let me get all your papers.
Your Honor,
Yeah, go ahead.
Before you start, and I'm sorry, I don't recall which case off the top of my head, but there's one with no insurance and he had provided me proof. So it would be my intention to dismiss that. I don't recall whether or not I have that proof before I directed the paperwork.
Okay.
That proof was given to my attorney.
Yeah, none of his guilty pleas have no insurance in them, so you must have already known which one it was.
Okay.
Thank you for that, Ms. Gardner, anyway.
You're welcome.
All right.
You give us these numbers really quick. I'm sorry, we weren't prepared to have these on, and I don't know his case numbers.
Oh, okay. All right. Well, they're going to change, Denise, on account of these are Fs and they're going to turn into CRs, right? But they are 21 F 23, 21 F 83, 21 F 162.
Thank you.
Anytime. All right. So, Mr. Udy, raise your right hand for me, please, sir. Do you swear to tell me the truth, so help you God?
Yes, sir.
All right. Thank you. So let's look at these. And I don't really care what order we go in, but I usually just try to go numerical because it makes as much sense as anything else and more sense than most stuff. All right. So in this case, you have a series of documents here that I'm looking at. One of them is a motion to enter a guilty plea. Then there's a document called an information. There's a waiver of rights, and there's an offer on a plea of guilty. In fact, you've got those documents for all three of your cases. So do you recall going through and looking at all these documents before you sign anything?
Yes, sir.
All right. This is the motion to enter a guilty plea that I referred to. Does that look familiar?
Yes, sir.
All right. Here's the signature page. That is not probably your actual signature.
My permission was given, yes.
Yeah. I'm no detective, but that's what I think. All right. There is a waiver of rights, and that similarly, it looks like has a what we call a virtual signature on it. Then there's the Commonwealth's offer on a plea of guilty. I didn't mean to throw that at you. And that's got your virtual signature on there as well. So are you acknowledging that you looked at all these things and authorized your signature to be placed on it remotely?
Yes, sir.
Okay. Before you did that, did you make sure that you understood what it was that you were signing off on?
Most definitely.
Okay. Do you understand that you have the right not to incriminate yourself, but if you voluntarily plead guilty, you waive that right?
Yes.
You have the right to to have a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. You can confront and cross-examine witnesses, and you can put evidence on in your own defense. You understand that you waive those rights if you plead guilty?
Yes, sir.
All right. And you have the right to appeal, which you also waive if you plead guilty. Do you understand that?
Yes, sir.
All right. So do you feel like you're under the influence of anything today?
No, sir.
You feel like your judgment is impaired for any reason today?
Not at all.
Are you satisfied with the time that you have had to discuss these matters with counsel?
Yes.
All right. In 21F023, the Commonwealth is making the following offer, okay? Count 1, possession of a controlled substance, first degree, first offense. That is a Class D felony. On a guilty plea, the Commonwealth is going to recommend a 2-year sentence. Count 2, drug paraphernalia, that's a Class A misdemeanor. On a guilty plea, the Commonwealth's going to recommend 12 months. Count 3, possession of marijuana, that is a Class B misdemeanor. And on a guilty plea, the Commonwealth is going to recommend 45 days. Right? All to run concurrently for a total recommendation of 2 years. The Commonwealth agrees to supervised probation for a period of 2 years on the condition that you cooperate with probation and parole, follow the rules that they give you, and specifically that you would get an assessment for substance abuse where they could recommend any, or where they could decide if they needed to recommend any treatment for you. If they did, that would be part of your probation. Okay?
Yes, sir.
And then this is the one, you had a charge of license not illuminated, license plate not illuminated, failure to produce insurance card, and no insurance. And the Commonwealth is agreeing to dismiss those charges. Okay?
Okay.
So is this what you thought you were agreeing to? What I just said?
Yes.
All right. Other than what you and I just talked about, have you been promised anything to get you to plead guilty?
No.
Has anybody threatened you to try to get you to plead guilty?
No, sir.
Do you feel like I am making you plead guilty?
No, sir.
All right. Mr. Udy, are you telling me that you acknowledge on January 14th, 2021 in Berrien County that you were in possession of, knowingly and unlawfully in possession of methamphetamine, a Schedule II controlled substance, as well as drug paraphernalia and marijuana?
Yes, sir.
All right. All right. Fair enough. Moving on to 21F83. That case has a charge of possession of a controlled substance, first degree, first offense, Class D felony, for which the Commonwealth would recommend a sentence of 1 year plus a possible fine and costs, and would agree to probation under the same terms and conditions that we just talked about in the previous case, probation to last for a period of 2 years. Is that what you believed the agreement to be in that particular case?
Yes, sir.
All right. And has anybody promised you anything other than what the Commonwealth is recommending?
No, sir.
Has anybody threatened you?
No, sir.
Do you feel like I am making you plead guilty against your will?
No, sir.
Are you acknowledging here voluntarily and of your own free will that on February 21st, 2021, in Berrien County, you knowingly and unlawfully possessed methamphetamine?
Yes, sir.
Okay. Thank you. Moving on to number 3, the Commonwealth is recommending the following. Count 1, possession of a controlled substance, first degree, first offense, a Class D felony. The Commonwealth recommends 2 years. Count 2, possession of drug paraphernalia, a Class A misdemeanor. The Commonwealth recommends 12 months. Those would run concurrently for a total of 2 years. The Commonwealth would agree to probate that sentence on the same terms and conditions as the previous 2. The only, curveball on this one is that the Commonwealth agreed that the prior 2 would run concurrently with one another, but the offer of the Commonwealth in this case is that this one would run consecutive to those other 2. So if you ever got your probation revoked and
Yes,
had to serve all of these, those 2 you could serve at the same time. This one would be tacked on.
I am aware of that, yes.
Yeah, all right. Other than that, have you been promised anything to get you to plead guilty?
No, sir.
You've been threatened to try to make you plead guilty against your will?
No, sir.
You feel like I'm making you plead guilty?
No, sir.
Mr. Udy, are you admitting to me that on March 19th, 2021, I missed, 2021, you, in Berrien County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes, sir.
All right. Then I'm going to accept your guilty plea on all 3 of these cases. Presumably, you all have, and you may not have, but presumably you've discussed that you can waive a pre-sentence investigation since everybody agrees, the Commonwealth agrees for you to be on probation and you're in custody right now. And I can go ahead and sentence you, and then you can report to probation and parole
Yes,
tomorrow, and so on and so forth, right?
Yes, sir.
All right. So I am going to hand it over to Officer Mann with probation and parole. If I can find her.
I'm
And-
here.
All right. I've got y'all on a different, I don't have you on the gallery here because I've had too many people. All right. So Officer Mann, will you tell Mr. What's going to happen is he's pled guilty. We'll send a commitment order to the jail and they will know that I'm probating him, so they won't have to wait for the judgment, which will take a day or 2. And they'll go ahead and release him from custody unless he's got some other kind of hold, and he can tell us if he does. And then he needs his marching orders from you.
Okay. Do you have a good phone number?
I do have a good phone number, but I'll have to reactivate once I get out. I can give you the home phone number until I get it. It's 270-537-3060.
Okay. And what is your current address?
425 Caveland Road, Cave City, Kentucky.
Okay. I want you to report by phone to the probation and parole office in the morning by 9 a.m.
No
Do
problem.
you have a pen and piece of paper? I can give you the number.
I do.
Okay. The number is 270-678-7443.
Got it.
Okay,
Thank you.
thank you.
Thank
All right. Hey, listen,
Go home.
be sure to give them a call first thing in the morning, okay?
I will, sir.
All right, man. Good luck to you.
Hey, I thank you so much.
All righty.
Sorry, I can't even think right now. Trembling. Ready to go home, see my mama.
All right. Bonnie, does that do it?
Judge, that's got it.
Bless your heart.
All right. We're gonna see you Thursday morning.
Thursday morning at 8:30.
You betcha. Thank you.
Thank you, Judge.
All right.
Judge, before we start, I know that Mr. Rocky is on here to enter a plea. I was just wondering, since we still have a number of cases and it's getting to the end of the day, if she would be available on Thursday at 8:30 to appear, if that would be okay with you.
That is okay with me. I don't really know if we'll be able to do. Hers is, she's got, it had an issue with her connection. She's come
I
in and
know.
out of the meeting about 7 or 8 times.
That's what I thought. Well, maybe she could figure that out before Thursday.
Ms. Duragi? I'm not sure that she's on even as we speak.
Okay. I'll just email her attorney. I can't recall whether it was Candace or Robert. Denise, if you wouldn't care to ask them to maybe
I'll
get in
tell
touch
you
with
who
her.
signed off on it. I'll tell you who signed
Okay.
off on it if you'll give me a second. Robert.
Okay. I'll get in touch with him and see if he can arrange something with her.
Okay. I would be more than happy to fit hers in with everybody else's on. I mean, not everybody else's. There's just going to be a couple, but we may just stash that one in our back pocket for Thursday. Okay. Okay. All right, Ms. Gardner. Who else do you have in mind?
I know John and I have some cases, and I think Mike has one with Johnny. We want to start with Pamela Bryan.
Mr. Bell?
Yeah, that's fine.
I think
Pamela
she's
Bryan?
in, Judge, she's in residential treatment. I think if Johnny could tell us how long he expects her to be there. And set a pretrial. Johnny,
Mr.
you're on
Bell.
mute.
Yeah, I can't hear you.
Yeah, sure, that'd be fine.
When is she expected to complete treatment or be available, Johnny? He's still on mute.
Yeah.
Judge, I apologize, I was on the phone with Judge Reed in Hart County.
Oh, okay.
When you're lowly as me, any judge in the United States call, you have to answer.
I can dig it.
I'm even glad to see Reese or John or Mike call. I'm tickled to see them call. It makes me feel good.
All right. So,
That's a lie.
Gardner,
But anyway.
go through that again.
I'm sorry, Judge.
Go through that again, what you said, Ms. Gardner, will you?
I think John's note is that she's in treatment. We just need to know when she would be available for a pretrial conference.
Which one are we talking about? Pamela Bryan?
Pamela Bryan.
She gets out in June.
So are you saying
And in
you,
June.
you want to go after that?
Yes, sir. Matter of fact, I've got two in rehab that's like that. One is Pamela Bryan and one's Crystal Davis. If you want to set both of them at a similar date.
I don't think Crystal Davis is on, is she?
I think so. Well, the judge says no, but okay. I'll strike
Well,
her from my.
I don't know if she was supposed to be on or not, because I don't recollect that far back, but she isn't on.
I thought she was supposed to be, but it doesn't matter, Judge. She's in rehab anyway.
What were you hitting on? Sorry. Yeah, I'm sorry. All right. Can y'all look Crystal Davis up and see if maybe we have a different day? If we set this off and you want to, it's a good time for everybody and you all end up, I mean, you can do an agreed order to move that other one. I don't care.
Okay, fine.
You want to do July Risa, when did you say you might be gone? The 12th?
No, the week of the 19th, but I believe I have every trial set that week. John
okay.
will be gone for sure. And if we resolve every trial that week, then I will be gone as well. Emory is a World Series that week.
Thanks.
I hope I got one set that week.
Yeah, I bet you do.
I do.
I think you do, Johnny.
Because
you actually have someone who has like 4 or 5.
She'd be wanting to resolve that bad.
Nope.
She didn't have a bearing. So do you not want me, just throw out a day that is okay with you, Risa, and I'll put it on there.
Well, I think that first date in July would be fine, or the 15th, the first Monday that's not a holiday.
Yeah, that's the 12th.
That would work.
Okay. Seven, 12, 1 o'clock.
I've got some others here. Anytime you want to resolve them, Judge.
Waiting on me, you waiting too long.
I was just going to call John's. I was going to call John's that were Johnny had, and then I was going to call mine. And then Mike, I think he has one.
Go ahead.
Or 2. Christopher Holder.
Judge, that's my case. He is not present today. We have an offer in his case. I'd like to make a counter offer. If we could set him out a little bit, I'll get that done.
John's note is that he isn't in custody, but he was supposed to be present today.
I don't recall that. I don't
And
know.
if we are going to move this for a pretrial, it needs to be sooner than later because it's been pending for quite some time.
Okay.
Yeah, I mean, there's two, I guess it kind of cut. I mean, I think Johnny's just been in it for about 6 months, but it has been pending for 2 years.
I will admit, Judge, I've only been in it since I think October or November or something, but I've had enough time to make a counter offer. It's just kind of slipped by me. But I will try to get that done.
Well, I mean, I'm going to put him on the 19th. I feel relatively confident that he's, if he's gonna, he wasn't here the last time we said it, and I think we said we wanted him here. Now, it's hard for me to get too worked up over him if he wasn't here for me to tell him to be here. But I mean, if he ain't gonna be any better at staying in contact with you, then sooner or later, I'm gonna have to do something about it. So I want him here on the next, I'm gonna do April 19th, and I'd like him here then.
Yes, sir.
All right.
And then Gregory Parker.
Mr. Parker, I have filed a motion to suppress and memorandum in support. We just need a date to get a hearing on that, Judge, and he is present here at the office. Come here so they can see you, Greg. There's Mr. Parker, Your Honor, President of the County Bar.
When did you file your motion? I don't have it.
When we file that motion, Angel? We filed about 10 and we done about 8 more this morning.
Oh, let me back up. You filed this motion a long time ago and then we canceled the
Yes.
hearing. So
Right.
if that's the motion you're talking about, I do have it.
Okay.
It was like September.
Yes, sir.
All right.
I think somebody, I don't remember, I don't really recall why, to be honest.
Well, things
Johnny
got
called.
shut. Yeah,
know-
right when we were supposed to have the hearing, things got shut down and then
Right.
we didn't have it. We were gonna do it by Zoom and I don't remember why we didn't, but we didn't.
That's it. You sit down, brother, if you want to.
All right, when do you wanna, well, we can do. I'd like to do it, I guess, over towards the end of this month or the end of April. You want to do, let's see.
On April the 27th afternoon, I'm completely clear the whole evening.
April, the what date?
That's a revocation afternoon.
Yeah.
Yeah, Tuesday.
You
Yeah.
said the 27th.
Yeah, you probably won't be free. You'll probably end up having some of them clients with revocation hearings when the time comes.
28th, I've got 9 o'clock till about 9:30, and then after 11, I'm clear the rest of the day. That's a Wednesday. 29th, I can do it anytime, all day on
John's
Thursday.
free that day as well, Judge.
All right, let's do the morning of April 28th, because we'll have our project meeting, but that's not until the afternoon, so I can do the morning.
Can we set that at 8:30, Judge, to start, because I've got to be in Metcalfe County at 10, and I'm assuming we'll be back in court by then.
You know, no, that's April. We'll still be Zooming.
Oh, okay, that's fine then.
You know, I don't ever like to do stuff as early as you do.
I wish I could hire you to milk a cow. I'd get a milk cow if you live together.
You all the time wanting to go early in the morning and
Yeah, and show up an hour late.
all right, so 28th at 8:30. Okay?
Yes, sir. Is he free to go, Judge?
Yeah, now, I mean, listen, if you and John want to talk about it and you all want to try to do it live, because there aren't going to be a lot of people, we can do, I think, just like a case by case, but I mean, it would just be you and him and the Commonwealth and their witness. So I just need to be notified ahead of time so that I can make arrangements for everybody to get in.
Zoom's fine with me, Judge.
I'm going to treat it like Zoom unless I hear something different.
Yes, sir. I'm gonna talk to Mr. Gardner and hopefully see if we can take one more stab at resolving it before we get to the expression date.
All right. Well, that wouldn't hurt my feelings.
I understand.
All right. We'll see you then.
All right. Thank you, Judge. See you, Greg. Okay.
Judge, we also have Paul Wilson. My last note in the case is that Johnny was going to file a motion to suppress. I have not received that yet.
Come on back, Big Mike.
Maybe it's one of those
I worked on that.
20
this
that
morning.
he's filing.
I worked on that this morning, Your Honor, and it wasn't right. After I got to going through it, I need to make some amendments to it, and I will get that filed hopefully this week. I was hoping to have it filed by this morning, but it just wasn't right.
Do we want to go ahead and set a hearing date, Judge, if we want to do,
Is this a John case or a Risa case?
it's a RISA case.
Okay, well, yeah, let's go ahead and set it. Since I have you on here.
I could do later in the morning on April 29th. I don't know if Johnny had said that he was available that morning.
I'm available all day on 29th.
When you say
Usually
later,
I'm done with district court. Like, I'm usually done with district court around 10 o'clock.
okay. So you want to do 10 on the 29th?
That would work for me.
That's fine with me.
Okay. All right, we'll do it. Next.
I think Mike has Terry Hagan with Johnny.
Okay.
That's my last case. We filed a suppression motion and I believe we filed it this morning, Judge.
Johnny, I looked on CourtNet and I got what you filed. What I got was what looks like a bill of particulars and then a request to amend his bond conditions. I didn't see a motion to suppress in there though. I'm not saying it didn't happen, but I don't see it on CourtNet and I don't have it.
I'm sorry, that it was, we filed a suppression motion. We've been working on one, but we done a bill of particulars. And then we supplied some information concerning his grandchildren and being able to see them, Judge. We'd like to be heard on that too. I think social services allows him to see him under the supervision of his daughters, but his bond would prevent that.
Okay. I mean, are you saying that I guess I don't know what the Commonwealth wants to do. Do you want to set it for a hearing? Is that what you want to do?
Unless, I'd rather wait to get the bill of particulars because I'll be filing a motion after that. If I don't know if Commonwealth would just agree to amend his bond when it comes to visitation with his grandchildren to be overseen by CPS.
I think we talked about this the last time and, we were supposed to talk about it before then. I wanted more information and then, I get these filings and these affidavits. I haven't talked to any of these people. Due to the nature of the charges, I'm not willing to outright agree to any changing of any bond conditions. I'm not saying I won't agree to it, but I'd like to talk to some of these people before I go and do that.
And that's fair, Judge. I mean,
just got the paperwork.
I'm not trying to blindside him. If I could get
No,
by
I'm not
with-
saying you are. I'm just saying.
Oh, I understand. You're 100% right.
I'm just saying. Yeah, I'm just saying I haven't had a chance to talk to these people. So
Sure. Maybe if we could pass him to the 12th to come back and hear Mike's decision on this and make sure we've got a bill of particulars and then set a date for a hearing as far as the suppression.
Yeah, I mean, that's fine. Mike referenced something about affidavits. I don't have any affidavits attached to this motion. So that if there are some, they didn't get filed with the motion, or they didn't get printed if they did get filed.
I got it. I got it in the form of an email, so I don't know if it looked like a filing because it looked like there was a motion attached to it, but maybe it was just I was looking at the affidavits itself and the heading, but
Yeah, no, I've got the motion.
I mean,
I got
John,
the
if we can.
I got the motion for a bill of particulars, although it's not styled that, but that's what it is. Motion for no further notice. But it's, it's in the form. It's the substance of a motion for a bill of particulars, but I didn't get anything about a bond.
And I'll have to ask her, Judge. Like I said, I worked on those this morning and there was several of them, and I may have, I need to,
Well, let's pass it to the 12th and you all get squared away what your, what order we're going to go in, what we need and all that. And then we'll, that way we'll have it.
my
I'll see
understanding
whatever I
is,
need.
Your Honor, we sent the affidavits to Mr. Richardson in hopes that maybe we could agree upon it. If so, we wouldn't have to go any further with any filing. So that's the reason we sent it to him, and we sent the particulars both to you and Mr. Richardson.
Yeah, I understand. I mean, I'm not criticizing you. I'm just telling you what I don't have what he's referring. So I don't,
Yes, sir.
what he's referring to, but we'll, when we get here on the 12th, you all have talked in between now and then. And if I need to set a hearing on some of this stuff, then I will.
That'd be great, Judge.
All right.
That concludes my business. Y'all have a good day.
All right. See you.
See you.
Thank you, Judge.
Could we call Paul Coomer?
Mr. Coomer.
Yes, I'm here.
All right.
This is one, Judge, that Ms. Myers and I have negotiated on and didn't reach a resolution. I think we need a trial date. One thing that I don't know if I was clear on my offer was I had an alternative sentence, and I would be willing to do that on home incarceration. I don't know if that would change, his mind, or if you wanted to talk to him further about it, or if you felt like we still needed to set a trial date.
Might change his mind. I'd like to actually talk to him a little bit further about that.
Can
we pass it to April 12th then, Judge?
Yeah, if I do April 12th,
Would that
can you all
work
get
with
together on
Xanda?
that?
Yeah, that gives me enough time to meet with him.
All right. Paul, Mr. Coomer, make an appointment to talk to your lawyer. We'll put it off 2 weeks and let you all chat, okay?
Okay.
All right. April 12th at 1 o'clock, okay?
Okay.
And then
Go ahead.
there's Jason
okay.
Akers, Judge.
All right. Mr. Coomer, that's all we got, okay?
Okay, thank you.
Thank you.
Have a good day.
You too. Mr. Akers,
Yes.
all right.
I think Jason wants to
I
take.
think we're
the
close
offer.
to a deal.
Yeah, I think he's wanting to take the offer from what I heard. I can probably get the paperwork to him either Tuesday night or Wednesday night for him to sign if the court would allow me to put him on for Thursday at 8:30.
Fine with me.
That works. Do you have the paperwork,
I think
Xanda?
I believe I have all the paperwork.
Okay.
I know that there's a DUI as part of it. Do you all need a motion to enter a DUI guilty plea as well on it?
No. I've always
No.
traditionally, and Judge Patton the same way, we just did the regular motion to enter a guilty plea and just go over the DUI stuff,
Okay,
We don't have to have two separate motions.
okay. Then I should have everything I need.
Okay. Mr. Akers, can you get back on Thursday morning, which is April 1st?
Yes.
And we'll do it at 8:30, okay?
April 1st at 8:30.
You bet.
Thank you, sir.
Thank you.
Jason, you need to keep in touch with me so we can set out whether or not I'm gonna meet you Tuesday night or Wednesday night, okay?
Okay, I'll call you in.
Call me Tuesday afternoon, and as soon as I get out of court, I'll try to set up a date or time with you, okay?
Okay.
All right.
So I'll call you anytime for lunch.
Thank you.
Oh, thank you.
Judge, John had Compton with Xanda as well, and I think that we just need a new pretrial conference in that date.
All right. Is that you? Yeah, there he is.
Is that Mr. Compton on there?
Yep, he's Phoenix 5.
Okay, I'd had a little I don't know if he's getting my messages or not.
I've got your messages, but somehow it got deleted.
John,
I had to call the clerk's office to get a meeting ID number again. My phone I got AT&T and where I live at, I stay in the basement and sometimes I don't receive, I can give you another number maybe.
I just need to make sure I got a way to get a hold of you.
Right. What's your number? 270-670-5443.
Okay, thank you.
Thank you.
All right.
when
so,
do we need to set this, Santa?
Yeah, how far out do you want it?
The next trial or the next pre-trial date that's available should be fine. I think that's what, April 12th, is that right? Yeah, that should work.
Mhm.
All right, Mr. Compton, I'll see you on April the 12th. That's 2 weeks, okay?
All right. Thank you, buddy.
Same time.
Okay. Thank you.
You bet. Good luck. See you.
And Judge, John had two more that I think should be fairly quick. He has notes left for me on Nicholas Hodges, but I don't see that he's on here.
He's not. He's in
There was a
Adair
motion to
County
revoke
Jail.
probation that we just needed. Okay,
You know how, I'm not sure we've ever been able to get them to get on,
yeah.
even though they tell us they will.
Right. And then, I guess, do you want us to try to call up there or do you want, I think the last person we had was Charles Perkins, who Stephen Poindexter he had. And we almost got him on from Adair County, but they ended up transporting him back to Barron County. So we didn't have to deal with Adair.
Yeah, this is just to set a hearing, right?
Mm-hmm.
Yeah. Which, he's going to be in custody until we set the hearing. So it's not strictly speaking required that he be here for this part of it, as long as I just set the hearing and let his attorney know, and then his attorney can reach out to him and try to talk to him before you know what I mean? Because we used to just, back before we had so many, we used to just have the hearing right there. You'd file the motion and have the hearing right there off the bat,
Right.
So I'm not going to delay it in order to get him here just to tell him that his hearing is going to be another day when he's not going to be required to get himself here because he's going to be in custody. We'll just go ahead and set it for April the 13th at 1:30, and then we'll work on trying to figure out how to get them involved in cooperating with us.
Okay.
Okay. And I think this is, Greg, is this yours?
That works.
I'm finally unmuted. It is.
Okay. So you catch what I'm saying?
Yes.
All right. April 13th at 1:30.
Okay.
And then he also had Rachel Polston, and I believe Josh is representing her and had told John that she is in labor. So
yeah.
And what now?
She will not be available.
Judge.
Labor.
Sometime between.
What now? Labor.
Yeah. Yeah, we got a call at the office about, I think, between courts today, or actually towards the end of morning court. And Monica emailed me, sent me a note saying that Rachel was on the way to the hospital. She was having contractions. So they're sending us proof. I don't know how long she's going to be in the hospital or whatever. So.
Wow. I didn't know she was that close to delivering. Of course, I guess it's been almost 3 months since we saw her. All right, well, let's put her, I mean, gosh. 4 weeks sounds like a long time unless you've just given birth to a baby, and then it's probably not all that long. But you want to try to put her on for like that last Monday in April, because she'll be able to Zoom and we wouldn't have to have her come in person. So it might be easier than trying to set her up. I mean, once we start going back to in person, we ain't gonna be doing this. You know what I mean? I mean, people are gonna have to come. We're not gonna have half of them Zooming and half of them in. It'll be like we did back in the summer. You know, we'll do the
Yeah.
jail dockets by Zoom or whatever. We'll do them at the end of the docket and, you know, so I would expect her to be here, but we'll do April 26th.
That'll work.
Do
Sounds
it
good.
from the comfort of her couch. All right.
Judge, I think that's all for John and for me. If I'm wrong, just call me. I'm headed to Cumberland County. So.
Dang.
Mm-hmm.
I've drawn the short straw before too. I'm just kidding.
The weather's nice.
Yeah, it's Emery's first high school game and she's starting third base, so.
Yeah, no, that's important to go to. I agree.
Just call me.
I've had a lot of fun. I've had a lot of fun in Cumberland County over the years, so I was just joking. All right, see you.
All right, thank you, bye.
Judge, could we call Travis Wilson? He's been on here all day. I just got a quick message to deliver on him.
All right.
He's
Deliver away.
Mike and I find we've got this resolved, and I just don't have the paperwork done. I guess we could do him Thursday if you want to do it then, or put him on the next motion day. I don't care, Judge.
Travis, can you hear?
You may not be hearing us.
Travis, can you hear us? We can't hear you. I guess that's the issue.
Give a thumbs up if you can hear us. That didn't work either.
Yeah.
Okay.
I mean, it says that you have volume. I mean, it says that you have microphone capability, but it's either turned down or there's some other issue. Like you're hooked up mic-wise. Gives me that makes me feel uncomfortable. I mean, he's been able to talk before, so I don't know what the situation is today, but
No.
maybe he can get it resolved by Thursday and we can try to do it Thursday.
That's fine, Judge. You just go ahead and put him on there, and if for whatever reason he can't make it, we can, do another day or something. I mean,
Travis, we're going to try to do this on Thursday morning. If you at 8:30, if you hear me, give me some kind of sign.
I'm sure he's muted. He's not.
Well, he is muted, but if he didn't have microphone capability, you wouldn't see a mute button. So like some of these people that get on their phones, you can't mute them or unmute them. And that means their mic isn't hooked up, but he's got audio capability. It's just not working for whatever reason, or otherwise that mute button wouldn't show up, but
Okay.
maybe you can work on it. Call a friend, practice Zooming with them, whatever. And we'll try to do it Monday. We'll try to do it Thursday morning at 8:30.
Okay, Judge, Travis, if you can hear me, I'll email you the paperwork. You sign it and email it back to me. Okay?
All right. Thank you.
Judge, I've also got Brent Dobbs.
Right.
One of Myers' clients.
Right.
They've given me some documentation for the possession charge. And I just need to look that over again, and there'll probably be some changes to the plea agreement that I've offered. If we could put this on the 12th, if we don't have too many cases already on there.
It'd be all right. We can do it. April 12th at 1 o'clock.
Yes, sir.
Mr. Dobbs, can you hear me?
Yes, sir.
Okay. Oh, look at that. He sounded like a clear as a bell.
April 12th at 1 o'clock, correct?
I don't know how come his sounds so good when I don't even hear any background noise on his. It's like a miracle. Wherever you're doing that from, do it from there the next time too.
Yes, sir.
All right. All right. April 12th at 1 o'clock. Okay.
Yes, sir. Thank you.
Yeah.
Judge, I've also got Charles Lester Busey Jr. That's one of Josh's clients. We talked a few days ago about this, and from what I've been told, Mr. Busey has not had any contact with Josh. I don't know if that's changed since then. I've already given discovery and an offer out there.
Yeah, Judge, it changed this morning. I was finally able to get a hold of him. I'm not sure if he's on here or not. If he is, I'm not sure, but I've discussed the offer with him. He wants a little time to think it over and discuss it with me a little further more time than I had this morning. So if we could push this off to the end of April when we come back for in person, I think we might be resolved by then.
Is he on here though? I mean,
yeah, I'm right here.
There he is. Okay.
Yeah, I was going to say he's got it. I guess he's borrowed somebody's phone.
No, it's my wife's.
Well, you still borrowed it.
Well, yeah.
You didn't just take it from her, did you?
No.
All right. You want to do May the 3rd?
Yeah, that'll work.
That's fine, Judge.
Mr. Busey, be sure you talk to your attorney before then.
Okay.
I'll be in contact with you.
All right.
We'll be live and in person, okay?
Okay.
All right.
All right.
See you.
See you.
Judge, I wanted to call Kim Ingram. I think that was one of Greg's, if I'm not mistaken. Greg, is that you?
Mm-hmm.
Have you talked to him? I've sent a discovery and an offer in this.
I'm
case.
right here. I'm right here.
Yeah, hold on.
I was talking to Mr. Berry, but Greg, have you talked? Have you and Mr. Ingram talked?
I'm looking for his file right now. Oh, here it is.
No, I never got to talk to him.
No, in fact, I've still got his discovery sitting here. So I would think we could work this out pretty easily, but I do need to talk with Kim.
Greg, do you think it's is it too ambitious to try to just put him over there on that Thursday morning and see whether you all have a chance to talk before then?
We could try that, Judge. You're talking about April 1?
Yeah.
Okay.
I mean, I guess worst case scenario, if it doesn't pay off, we'll just put it on another day. But I would think that given the nature of it and all that, now that he's on there, if y'all trade numbers or whatever you need to do, you can probably get him tomorrow or something.
I can make him an appointment for 8:30 Wednesday morning.
Just make it in the morning if you want to.
Are you?
Yeah, I understand. Is your number still 912-3557?
Yes, it is.
Okay. All right.
I called, but I couldn't get a hold of you last week.
Kim, they're saying that they'll do a go ahead and make you like a phone appointment right now.
Okay, that'll work. 8:30 Wednesday morning.
No, we're going to do 8:30 tomorrow morning, he said.
Is that 8:30 your time?
Yes, 8:30 our time, Central Time.
It'll be 9:30 mine. Okay. Now, do I call you or you calling me?
You will call the office.
I'll call him. I'll call him.
I'll get out of this.
That's okay. Usually it's easier to hook up if I call them, if I've got a number.
Yeah.
Okay.
So you gave Greg your number, right? Or he just read it back to you? All right. Super.
Yes.
All right. Carve out a little time for us on Thursday morning at 8:30, okay?
All right,
just in case.
okay. Now,
All
is
right.
it gonna be in person or gonna still
No.
be on here?
It'll be like this.
Okay. All
All
right,
right.
thank you.
All right, see you.
See you later.
Judge, another one I had was Rachel Myers Jackson. She was a no-show on our last court date. Greg was supposed to see if he could get in contact with her.
Do we have any info on that?
I don't, Judge. I've got a phone number on her, I've called it, but there's not I believe what the message is, there's not a voicemail set up. I think that was the one I tried and got that message.
Okay.
I've got a email for I sent her an email message, and I don't know if she got it or not, though. I've not heard from her.
Judge, I think the last time we talked about this, that she should have been aware of her court date. So I was going to ask for a warrant for her.
I mean, we had to do that the last time just to get her in. Was she, of course, I mean, we were meeting in person, but she didn't appear then either, and we had to end up doing a warrant to get her. And then she got arrested and got her court date and called a couple times and postponed it, but she did finally get arraigned. But I don't. I've been awful reluctant to do that, but at the same time, I think that might be required just to get her to
Judge,
show up.
I'd like to ask one more. I'll send one more email and try calling again and see if it does any, if I have better luck.
Well, okay. I'm gonna say, these are not inordinately, I mean, that doesn't mean somebody's guilty, but it's not an inordinately complex case. And like if she would be cooperative, the impression I get is that nobody's talked to her, for these past 7 or 8 months. And, that shouldn't happen even in a possession case. She should be available to talk to her lawyer when she's got a felony. I'll put it on the 12th.
Okay, Judge.
And we'll see where we end up.
Okay.
Does anybody see any other, the only thing, I was going to say, the only thing I remember is that we didn't do anything with Nick Hodges, but we set it for a hearing on the 13th at 1:30.
I think that's all I had, Judge. I'm not sure there's anything else left.
Yeah, it looks like that's it.
Okay.
All right, everybody. Hey, before we go off, let me tell you, I'm going to try to, as April goes through, you all have seen like we've had kind of spotty luck on this, but we're not going to continue all of these pre-trials and everything I'm not going to have the clerk send out continuances on those. We're going to leave everything on and just do our best. So if anybody contacts you or whatever, and they have a court date, just tell them, we're going to leave them on and we're going to try to at least accomplish whatever we can before May gets here and we're back live and pulling all of our hair out. I'm gonna have to let mine grow just so I can pull it out. Okay?
Okay.
All right. Thank you.